Lordship, I beg to mention item number 2. Lordship, I beg to mention item number 2, which is fixed for delivery of order, Lordship. Lordship.
Okay, you mention it when this item is called. We
Okay,
will.
Lordship. I need that.
May I say, for a bit
After
earlier
delivery.
of item number 59.
After delivery. Item number 1. For reasons mentioned in the order, the petitioner is allowed to go on bail of ₹1 lakh with 2 sureties of like amount subject to certain conditions.
Lordship, this matter may be fixed before the appropriate bench. Lordship, I was surprised, Lordship. They have not annexed the judgment of earlier, which is rejected by
Mr. Bodho is there. DK Bodho. I will not deliver the judge order now. We will wait for Mr. Bodho to come. Then let him also remain present when you make your mention. I'm not delivering the order. Let Mr. Bodho come. Itu ভিতৰত নপঠাব itu ৰাখি থব লাগে Here also, for the reasons mentioned in the order, the petitioner is allowed to go on bail of ₹1 lakh with 2 sureties of like amount with certain conditions.
Gotcha.
Okay.
Here also, both the petitioners are allowed to go on bail of ₹50,000 with 2 sureties of like amount with certain conditions.
Much.
For reasons mentioned in the judgment in the order, the prayer for bail of the petitioner is rejected.
Item 6.
For reasons mentioned in the order, the petitioner is allowed to go on bail of ₹1 lakh with 2 sureties of like amount with certain conditions.
Yes.
Yes.
Please, the Lords. So I'm praying for listing of a bail application also. Anticipated bail application.
Listing, no time is there.
Lordship,
When do you want?
Lordship on 20th tomorrow, Lordship. Last
Let
day,
it come.
it was filed on
When have you filed?
25th of June.
What is the matter?
Lordship, regarding this is some whatever was there, Lordship, between 2 persons and
Now, what are the offenses?
offense was under 353. The public servant was also involved, and 186 and Lordship. Lordship, less than 7 years. All right.
Okay.
Lords.
May I please,
Okay.
the Lordship? Matter, supply item number 75. My Lord, this is a leftover matter on Tuesday, my Lord. And my Lord, there is no entry, my Lord. Could it be, my Lord, taken up at 2, my Lord? Otherwise, bench is also rising at 3:30. Anticipatory bail. CD is also here, man.
71.
75. That is available, man.
Okay.
Highly available.
May I please, Lordship, my Lord. Item number 42, my Lord. CD is received, my Lord. And I have instructed today, my Lord, that the petitioner's mother is seriously ill, my Lord. So, my lord, since the petition is there, my lord, may I pray for my lord, taking the matter, my lord? At two, my lord.
Now, two we have fixed. You are behind the bars.
Yes, my lord.
Now we'll take in item number
42, my lord.
42, we will reach. We will reach.
Okay.
May I please tell lordship? My lord, pursuant to your lordship order, my lord, I filed bail application before the trial court, my lord. But my bail application was rejected. I was taken to custody, my lord. So this bail application was filed on 25th, my lord. Kindly tomorrow, my lord, for this.
What is the matter?
Matter, my lord, NDPS, my lord.
NDPS, you have to,
My lord, this is your lordship's order earlier disposed of by your lordship.
okay.
Tomorrow, my
Lordship, similar matter.
lord.
My one is.
May
Obliged,
please, Lordship, I pray for listing of a IA Lordship on tomorrow. Lordship. Extension of order Lordship. I was supposed to appear before the IA
Who
Lordship,
passed the order? This court.
this court Lordships.
Okay.
Deeply obliged, Lordship.
May I please, Lordship?
Good morning.
I beg to mention item number 44 for withdrawal, Lordship.
Withdrawal.
Yes.
Heard Mr. What is your name?
AK Azad.
Heard Mr. A.K. Azhar, learned counsel for the petitioner, who prays for allowing the petitioner to withdraw the instant anticipatory bail application. Prayer is allowed. This case is dismissed on withdrawal.
Number 15, my lordship, may I pray for a bit earlier, for urgent matter, as urgent matter, because of my, one appointment of the doctors for myself illness, my lordship.
What is your prayer? What do you want?
What, my lordship?
What do you want?
अपना की लगे prayer
For bit earlier, sir, bit earlier, item number 59.
upgrade possibly matter.
Yes, sir, my lordship.
59.
59.
Okay, after the already fixed matter at 2.
Yes, my lordship.
Orders.
Okay,
Orders,
let us see what urgency is there.
only one.
Okay, after at 2.
Okay.
May I please,
Like-
my lord, one unusual prayer, my lord, item 66, my lord. Here, my lord, twice it came out, but because of the amicus curiae for giving her copy, my lord, one date gone, and another, my lord, next date, my learned senior colleague, my lord, APP, he was, my lord, not, he was indisposed, that's why it could not be taken up, my lord. But can it, my lord, prior to your lordship rises if it doesn't reach, my lord, 66, my lord,
No,
BA, my lord.
your day. No, then it will disturb the list. Already we,
Kindly, my lord. It was in the list, my lord, twice, my lord. It reached also, my lord, but unfortunately, my lord, twice.
before rising if,
My
if,
lord.
if possible.
My lord, kindly, my lord, if possible, my lord, before.
May
I
I please, your lordship.
oblige.
Beg for listing of bail application for tomorrow, your lordship.
What is
It
the
a
matter?
468, it is, charges under 468, 420, 471, 34.
When have you filed?
Today, your lordship.
Then it will come before vacation court. You are late in filing. Let it come on. It will come, registry will list it in due course.
Thank you.
May I please, your lordship, regarding item 32, lordship, I pray for adjournment, lordship, the charge sheet matter, lordship, let us see in July, lordship, if some witnesses turn up or not, lordship.
On request of Mr. Item 32, on request of Mr. S. Muni, learned counsel for the petitioner, let this matter be listed after summer vacation on a date to be fixed by.
I pray, lordship, let it come in first week of August, lordship, because 2 dates will be there, lordship, we'll see whether.
Okay.
First week of August, lordship,
Okay, first week of August.
lordship, any date, lordship, convenience,
6/8. 6/8.
lordship, much obliged, lordship, much obliged.
May it please the lordship. Lordship, I beg to mention for listing lordship. Lordship.
What
Regular bill
matter?
office.
What matter?
Lordship, regular bill matter. Lordship, less than punishment, less than 7 years.
When have
We
you
have filed on 25, lordship. 25/6, lordship.
Okay, tomorrow.
Obliged, lordship.
May I please, your lordship, my lord, I would beg to mention item number 14, my lord. My lord, I would pray for a passerby in this matter as the conducting counsel, Mr. D. Gugu has to be out of station as he has some medical urgencies.
Heard, Mr. What is your name?
PH Kumar, my lord.
PH Kumar, learned counsel for the petitioner who prays for an adjournment on the ground that the Mr. D. Gogoi, who is the conducting counsel, is out of station. Considering the ground prayer is allowed, let this case be listed after vacation on a date to be fixed by registrar.
Madam, only possible for the day, madam.
No, there is no day left. Only 1 day is left. Let it come after vacation.
But if required, my lord, we may make a mention in the vacation code, madam.
Yes, that option is available.
Madam. Obligement.
Yeah, please, Lordship, I beg to mention item 50. Lordship, matter may taken after vacation.
You are in interim.
Lordship, I am on interim.
Why are you praying? His case diary is there. Heard Mr.
Yeah, along.
A. Alam, Learned Counsel for the petitioner. Also heard Mr. B. Gogoi, Learned Additional Public Prosecutor, who prays for some more time for producing the case diary. Prayer is allowed. Let this case be listed on 31st of this January, 31st of July, or case diary. The interim order shall continue till next day.
May I be Lordship, item number 49 may be withdrawn. As per my client instruction.
Withdrawn.
49, yes. Lordship. With liberty,
Heard Mr.
M. Hussain.
M. Hussain, Learned Counsel for the petitioner, who prays for allowing the petitioner to withdraw the instant bail, anticipatory bail application. The prayer is allowed. This case is dismissed on withdrawal.
May I please, my lord, I have filed one pre-arrest bail application, my lord. But finally, my lord, matter may be taken up tomorrow, my lord.
Matter relates to what?
Pre-arrest bail, anticipatory.
What is the offense?
My lord, section, my lord, 379 like that, because, my lord, this is.
Less than 7 years.
Yes, ma'am, 7 years.
Okay.
May I please, your lord?
Obliged.
I beg to mention item number 39, matter may be fixed at 2 p.m. my lord.
No, 2 we have already fixed. It will reach in normal course.
May I please, your Lordship? Item number 48, Lordship, I intend to withdraw, Lordship.
Heard Mr.
A. Thakur, Lordship.
A. Thakur, Learned Counsel for the petitioner, who prays for allowing the petitioner to withdraw the instant anticipatory bail application. The prayer is allowed. This anticipatory bail application is dismissed on withdrawal.
Deeply obliged.
May it please, your Lordship. Lordship, I am praying for listing of this bail petition, your Lordship, tomorrow, your Lordship.
Which,
This
what is the matter?
Your Lordship, it's related to section under section 354, your Lordship.
What is the maximum punishment?
It should be your Lordship 7 years. 7 years, less than 7 years.
Okay.
Like
Lordship, similar prayer, matter relating to POXO, Lordship.
POXO, you have to mention before the senior court.
Obliged.
May I please, Lord, for listing, my lord, AB 42406 for tomorrow, till 18. Obligement.
May it please, your Lordship. I beg to mention item number 25, madam. Perhaps it has been wrongly listed. Case has already been granted bail by a different bench. So perhaps, my lord, the matter may be listed before the appropriate bench. Item number 25.
Heard Mr. S. Das, Learned Counsel for the petitioner, who submits that in the connected case, one of the co-accused has been granted bail by a coordinate bench of this court, and hence registry may be directed to. Hence, he submits that this case ought to be listed before the same bench. So, considering the submission, registry is directed to list this case before the appropriate bench on 28/6/20.
Highly obliged.
Yes,
Yes, my lord. The matter may be withdrawn, Lordship.
heard Mr.
As such.
S. Hussain, Learned Counsel for the petitioner, who prays for allowing the petitioner to withdraw the instant bail application. The prayer is allowed. This bail application is dismissed on withdrawal.
Obliged.
May I please, Lordship? Lordship, this is approximate, settlement call for along with medical.
Heard Mr. as well as notice. Are on 23rd of July.
LCR may be called for lordship. This is a charge sheeted case.
This is a charge
Now
sheeted
we didn't-
case.
We didn't state.
No, case diary na lage. Instead of case diary, let the scanned copy of the case record may be called for from the trial court registry to issue requisition for calling the scanned copy of the case record. Let this case be listed again on 23rd July.
The affair is that he has stolen some, it's an unknown person has stolen some good things. That is gold ornaments and mobile phone. Ultimately, this person was arrested on 26, on 12/6/2024. Thereafter, his 3 days remand has been taken. Thereafter, and all the goods had already been recovered. My lord,
Okay.
you'll find in page number 19. The list of goods which have been alleged to be stolen, my lord, all have been recovered. Page 19 is the type 1, my lord, originally it is 19A.
No,
This is
case diary would be required.
Yes, this is I mean, due to the confession of the co-accused, this person is implicated.
All the goods have been.
No, we don't know the progress of the
Hmm.
investigation unless we peruse the case diary.
Not sure if it's in the, during vacation, my lord, on 3rd.
Let it be on 11th.
Yes,
Third, Mr.
that's what.
S. Boral and counsel for the petitioners. Also, Ms. S. Jahan, and additional public prosecutor. Call for the case diary. List this matter before. List this matter on 11/7/2023.
Yes. Obligation.
Ten counsel is not there,
None appears
8 remand,
after something.
after something.
May please. The case has been registered under section 354 and 8 and 10 and the POSCO Act.
Also is there.
Notice,
So matters today.
Lordship 55 days on behind the bar and written sections are.
With regard to her co-employee, my lord, wherein she has been alleged that on 12/6, she got out of office, I carried her in my car.
why it was rejected by,
Yes, it was rejected, my lord.
After perusal of the
because
case, that-
seven, this one, my lord, 41A was not complied with in this case because the punishment maximum is 5 years. So even then, my lord, if your lordship comes to the forwarding report, that is at page 25, my lord, we
No,
can see
Miss-
no
Mr. Bhuiyan-
reasons.
Mr. Bhuiyan,
Yes.
whether perusal of the case diary would be necessary.
My lord,
we-
not mandatory in these cases, my lord, where custodial integration is not necessary as
No,
such.
unless we go through the case diary, how will we come to?
No, my lord, will kindly see on the face of this record, whether 41A 11.6 of the Supreme Court judgment, which is mandatory, has been followed or not. Now, my lord, will kindly come to page 25 of the forwarding report.
Where is the rejection order?
A rejection order, my lord, will kindly come to that next page is the rejection order that starts from page 27.
Okay. Mention what? Mention what?
Where is the police station?
My lord,
Which police station?
police station Morigaon, man. Morigaon.
We call for the case diary, listing it before vacation court. Third,
Vacation, I won't be available, my lord. What I am on, my lord, we can consider, if can be considered. No, here is a person, 56 years of service, never been this. On 12/6, it was raining very heavily in Morigaon. And she being a Group D employee, I took her. I annexed a document, my lord, will kindly come to that at page 32 of my petition, my lord. This is the this I have got down, my lord, I have purchased a cake for myself. And thereafter in the affair also, my lord, she has stated that she has gone out from the car and to a, my lord, meat shop for purchasing. And thereafter on 12/6, nothing, no affair. 13/6, there is no affair. 14/6 comes into, and even my custody has not been taken into, straightway sent to judicial custody. Whatever are the allegations, these are on the face of this record, my lord. Whether
No.
my further custody is necessary, my lord.
No, let us peruse the case then.
I leave it to your lordship, my lord. That let it be on 15, my lord.
Okay.
15.
Heard Mr. A.K. Mia, learned counsel for the petitioner. Also, also heard Mr. B.B. Gogoi, learned additional public prosecutor.
15.
Perusal of the case diary would be necessary for consideration of the instant bail application. Hence, call for the same. List the
16, my lord. Let it 16.
My
not
lord is
15.
list this
PP, learned
matter
PP is praying for 16, let it be
on 16th of July.
16. I am obliged.
Item 63 from supplementary is.
439 application lordship offense under section 365 I think. Page 9 is the FIR.
365 case diary would be required.
Lordship. What happened lordship in this case? Lordship, as on today 27 days behind the bar, victim girl already recovered and given to the custody of her parent lordship. I'm praying on that ground only lordship. Already.
Where is the rejection order?
A rejection order lordship, there is
Bail application of Mohiruddin. Yes, yes, page 16.
page 16 lordship. Initial stage it was before recording 164 statement.
Learned counsel.
Let us see 164.
Acha, 164 will do.
Mr. A.K. Azab, learned counsel for the petitioners. Also heard Ms. S. Jahan, learned additional public prosecutor. Considering the nature of allegation leveled in the FIR, perusal of the case diary would be necessary. Hence, call for the case diary. Fixing
15 or 16.
16/7 for case diary.
Most of it.
Item 15.
No, I'm not with the measures of the 61 okay?
15.
15 now.
May please lord.
Oh. 15.
Yes.
This is Jimma petition.
Dream of petition, my lord. Caesar list, my lord. Is 17, my lord. 2 mobile phone were seized, my lord. And case has been charge-sheeted, my lord. I have annexed the charge sheet.
302.
Lordship.
302, yes.
Then, my lord.
He went
file
to
an
masjid
application.
and they attacked.
And I-
Unknown miscreants, of course, I detect with all sharp cutting
Why the
weapons.
Jimma was rejected?
Rejected on the presumption that it may be required in the trial. We are ready, my lord. And similar petition was filed before this small court, my lord. I have annexed it.
Page
Page
number
35.
34, Lordship will see there what they say, the prosecution is that it is used in the commission and the contents are required during trial.
Everything has been, my lord, examined by the charge sheet has already submitted, my lord, by keeping everything, and mobile has been
No,
kept.
if it is required, how can you speak Jimma?
Mobile has kept in Malkhana, my lord, now. In the charge sheet, it has
302 case, I mean, of course, if they have engaged someone else to kill him, that is a different issue. Then they will
Yeah, how
be
mobile is
speaking.
connected?
This is what I'm saying. If the accused person had engaged someone to kill him, then the issue would be different. Then there will be so many conversations. But now here,
all
they,
data has been collected by the IO, my lord. They have been.
after
recovered.
verification, that can be given in custody by the trial court. Or Lordship, I'll call for a report.
Similar order, my lord, I have annexed, my lord. Mobile phone, after charge sheet, my lord,
No,
trial court
we
rejected,
don't
my lord.
know, because the observation is that,
635.
Let me get a report from the IO at the earliest.
okay.
Charge sheet, my lord.
Charge sheet is done. Acha.
But already charge sheet submitted. So IO's report, my lord, for further, my lord, investigation will not come, my lord.
No,
And in the charge sheet, my lord, page 22, lordship kindly see. Mobile kept in Malkhana.
34 is also after charge sheet.
Uh-huh.
Okay.
My lord, lordship kindly see page 35. This is also after a short sheet, my lord. Trial court rejected.
No, you make prayer before trial court.
Yes,
In-
madam.
After committal, you have made prayer before committal court, which is not concerned with the trial. So it is the trial court which would be knowing whether mobile phone is required or not.
He can move
Okay.
an
So
application
after
there.
committal, you make prayer before the committal court.
Lordship kindly see, my lord, similar order, my lord. Several conditions were put. my
No,
lord.
similar order, we don't know the facts.
This is,
Whether
my lord,
how
please-
mobile is connected with that murder. If there is some connection of the mobile phone with the murder,
Now, my lord, during investigation, my lord, mobile was, my lord, examined by the expert. They collected all data, my lord. So, my lord, for further investigation.
you are accused,
I am, my lord, I have been implicated, my lord, subsequently
but you are
by the
accused.
lordship.
You
I
are
am one of
behind the bar or on bail.
I am on bail, my lord.
Okay, then case diary would be required.
I am on bail, my lord.
Heard Mr. R. Ali, learned counsel for the petitioner. Also. Also heard Ms. S. Jahan, learned additional public prosecutor. This application under section 397/401 of the Code of Criminal Procedure, 1973 has been filed by the petitioner impugning the order dated 15/6/2024 passed by learned additional Chief Judicial Magistrate, Kamrup Metro in PR case number 1341/2024 in connection with Hatigao PS case number 249/2023. Call for the scan copy of the PR case number 1341/2024, as well as the scan copy of the case diary of Hatigao PS case number 249/2023. Let this case be listed again on 23/7.
Large.
Item 16.
এটা হয়ে যাবে। 16
23.
May it please your lordship. Quashing petition, my lord, when I have moved it, my lord, notice was issued. And today was for interim, and as such, it has come for motion. But the case diary was called for, it's not been received. I have verified my.
Case diary would be required. Let it come in admission column.
Summary.
My lord.
Notice has been issued already.
It should be in admission column.
Heard Mr. A.K. Bhuya, learned counsel for the petitioner. Also heard Mr. B.V. Gogoi, learned additional public prosecutor, who submits that though the case diary was called for, however, same has not arrived. And
For considering the interim, my lord.
needs some more time for producing the case diary. When will you produce?
Summary, my lord, 16 of 2031.
16.
16, my lord.
Let it be on 16.
Let this case be listed again on 16th of
July.
July 2024.
Obliged.
17.
Yes, my lordship. This criminal petition is for quashing under police the
FIR is date.
police case number, sanctuary police case number 137, 2013. 2013, my lordship. The case was already suspected and the PW 125.
What is the ground?
Already examined, my lordship.
After examination, you are praying for quashing of FIR at this stage.
Actually, my lordship, from the FIR, it is transparent that the LS occurrence occurred on 13 July 2013, but the informant lost the FIR after more than 5 months, my lordship, on 7/12/2013, without mentioning the reason of delay.
So is that the only ground?
Yes, my lordship, all.
Any other ground? Delay is one ground.
Not mentioned ground for delay. my.
No, for your prayer
Yeah.
for quashing,
Actually-
one ground is delay. The FIR was lost delayedly. Any other ground?
Not only my lordship, it is pertinent to mention that PW2, the informant husband, admitted that the fact actually on 7 December 2013, he along with his friend Vichitra Das went to the house of the accused and tried to take away the mobile phone of the accused. When accused shouted Sur, then neighbors come and assaulted him and Vichitra Das. On these routes, the husband of the informant, with the intention to take revenge, had instigated his wife, informant, to lose this affair, my lordship.
Who is Hitesh?
Actually, all examine from 1 to 5.
No, you don't have a case. You don't have a case. I don't
Gotcha.
see. Because this is a sessions case where 2 witnesses have been examined.
5 witnesses, I see.
Five
5 witnesses
Even
have
the
been,
IO is examined.
and you are the accused,
Yes, my lordship.
and you are coming now for quashing of the FIR.
Actually,
That
my
too,
lordship,
without any on flimsy grounds. You can take all grounds before the sessions court where you are facing the trial. This is not a case for quashing.
And the delay ground she has explained in her deposition. Page number.
Delay cannot be ground for quashing.
Now, yes, cannot be. a
Any
ground
other
for
ground for any other ground?
Actually, my lordship, from examine 1 to 5, it is clear that this
No,
FIR.
Mr. Burman, Miss Burman,
Yes, my lordship.
on the basis of deposition of PWs, can you go back to quash the FIR?
Had it been a case that
You are facing the trial and PW said something. Now can go whether
For
you
quashing.
can for quashing of the FIR.
had it been a case, PWs had said nothing against him, then it's a case, she can make out a case. But now,
What will you do?
My prayer is, my lordship, to stop the trial, to stay the trial, and the disposal of this petition of my lordship. Maybe
Heard
an
Miss,
order to stay, my lordship.
heard Miss M. Burman, learned counsel for the petitioner. This application under section 482 of the also heard Miss S. Jahan, learned additional public prosecutor. This application under section 482 of the Code of Criminal Procedure has been filed by the petitioner Hitesh Kakoti, praying for quashing of the FIR on the basis of his Chanchari yes case number 137/2013 was registered, and ultimately sessions case was registered bearing sessions case number 22/2019. Learned counsel for the petitioner 2019 under section 376/379/506 of the Indian Penal Code. The main contention of the petitioner is that petitioner for seeking quashing of the FIR is that the FIR was lodged after a delay of 5 months of the date of alleged offense. She has also submitted that during the trial, the prosecution, some of the prosecution witnesses have made contradictory statements which belies the allegations leveled in the FIR. Do you have any submission?
that ground will not stay in as far as delay is concerned.
Learned counsel,
And at this belated stage, not
learned
possible.
learned additional public prosecutor submits that the petition, the prayer for quashing has been filed at a belated state and and solely mainly on the ground of delayed lodging of FIR. Stop. I have considered the submissions made by learned counsel for the petitioner as well as learned additional public prosecutor. It is no, it is a settled law that powers of this court under section 482 of the Code of Criminal Procedure have to be exercised sparingly in rare cases where the facts of the case justify such invocation. However, in the instant case, it appears that the petitioner has approached this court on the basis of flimsy grounds, seeking invocation of the powers under 482 of the CRPC, Code of Criminal Procedure. The petitioner has petitioner is facing the trial before the Sessions Court, and already 5 witnesses have been examined. Stop. Moreover, the FIR which the petitioner seeks to quash was lodged more than 11 years ago on 7/12/2013. This court therefore sees no justification in invoking in admitting the petition under section 482 filed by the present petitioner and invoking its powers under said provision. This criminal petition is accordingly dismissed.
May I please, my lordship? Actually, all examiner
I have passed the orders.
Okay, my lordship. Thank you. Not like my lordship.
What happened, Mr. Hallu?
That's why I just fell down in bathroom and broke
Both hands,
both hand fingers actually. 4 fingers were fractured, dislocated.
4 fingers.
4 fingers. 2 finger, little finger and ring finger. Here also little finger and ring finger.
Yes.
May it please my lord, I feel very sorry for my learned brother, lord, that falling in the bathroom these days, lord.
Very common.
At our age, she is very, very common. It happens. Lord, the impugned order, my lords may kindly have the pleasure, page 14, lord, paragraph 10, lord.
Okay.
The matter, lord, I would submit, lord, that is on page 14, lord. Is in a very narrow compass, lord, and my lords have only to look into the words in the statutes, lord. My lord will kindly have the pleasure. May I, if at all, my lord will permit, I'll read it, lord. Lordship, I have gone through the relevant case
Page 40 is something else.
40 is the finding of the court below, Lord. Page 40.
Oh, yes, page 40, you are reading para 10.
Page 40, last paragraph, not
Para
the
10.
bottom. Lordship.
Okay.
I have gone through the relevant case record. My lord got it, lord?
Yes.
I'm sorry, obliged. I have gone through the relevant case record. The special case number so-and-so is fixed for hearing on the stage of charge. At this stage, the accused petitioner has filed petition under 91 CRPC for calling of records, already mentioned. At the very beginning, I find it proper to quote section 91. Lord, the statute is quoted as verbatim. My lords will see on a reading of the statute, lord, my lords will kindly have the pleasure. The first 4-5 lines, lord, of section 91, where any court or any officer in charge of a police station considers the production of any document or the other thing is necessary or desirable. I lay some emphasis on the words used by the legislature, lord. necessary or desirable for the purpose of any. This is another word of emphasis, my lord. Investigation, inquiry, trial, or other proceeding under this court or before the court may issue summons to a person while in possession, believe him to attend and produce it. Now, lords, what happens that apart after quoting, my lords will kindly have the pleasure, page 42, verbatim pasting the statute as it is. Now, my lord, in paragraph 12 at the bottom, kindly have the pleasure, my lord. The case is posted for hearing on the stage of charge. At the stage, I am of the view that this is not a stage to consider as to whether the surveillance order which have been obtained by following a proper procedure. Lord, I lay some emphasis, Lord, on the word proper procedure. I would just take my lords to the Telegraph Act, Lord, what I had submitted. I also find the view that if according to the petitioner surveillance orders were produced without following the procedure, same can be demonstrated at this stage of trial. Now, Lord, and then he refers to a judgment of the Honorable Supreme Court, Lord, and then on that basis, he says that this is not a stage. Kindly come to the conclusive portion, Lord, kindly have the pleasure. And then after reproducing, Lord, at page 48 bottom, my lords will see judgment. I am of the view that the prayer for the petitioner for calling is liable to be rejected. Lord, in my humble submission, Lord, I beseech my lord's indulgence to submit that the necessity or desirability, Lord, of any proceeding, Lord, furnishing of a document, Lord, is not at all considered, Lord, only pasting the language of the statute, Lord, verbatim, and the judgment of the Supreme Court. Lord, in my humble submission, the law requires, Lord, consideration of the necessity or desirability. Now, what I submitted before the court, Lord, that there is a surveillance of my mobile telephone talks, Lord, and then my lords may kindly have the pleasure to see the Telegraph Act, Lord. Kindly have the pleasure. That is the section that authorizes, Lord, them to intercept a mobile or a telecommunication device. Kindly have the pleasure to see section 5, Lord, of the Telegraph Act. My lords will kindly have the pleasure, if my lords, yes, I am grateful, Lord.
Yes. Yes.
My lords, it is not conferring power for government to take possession of licensed telegraph and to order interception of messages. Lord, 1. The occurrence of any public emergency or any other in the interest of public safety, the central government or state government or any officer specially authorized in this behalf by the central government or a state government is satisfied that it is necessary or expedient to do so, may take temporary possession. Now, Lord, the prerequisite as per section 5, Lord, in my humble submission before my laws is that there is a public emergency or public safety. Lord, unless the preconditions of this and the corresponding rule 419, Lord, the draft rules enunciated and considered by the Honorable Supreme Court, Lord, which is referred to, there is no whisper in the order that whether what is the emergency and what is the necessity. Lord, they are discussing something and then, Lord, by usurping power under section 5.
At what stage the case is?
Yes, framing.
Framing of charges.
Yes, Lord.
What
I'm only submitting one thing, Lord, if my Lord would permit.
Let me understand.
Lordship.
What is the accusation against you?
Accusation is, Lord, that I was planning to give him bribe for something to be happening in future.
Okay, and for that your phone will.
Lordship, they say
that is not the allegation. He had given, not planning, already executed, and he was doing that show for last many years. That was the allegation.
For that, nothing is there. Lordship, I am not claiming my defense at this stage, Lord, at all. I would very humbly submit, Lord. What I want to know, Lord, Lordship, by exercise of power under section 5, if they do so, then there is a review provided. The review order has to be there by a superior authority. I am only asking for the document, my lord, to ensure a free and a fair trial, my lord. Nothing more.
At this stage of charges, where is the question of allowing the accused to produce document? It will
No,
be,
my lord,
no,
my lord, in my humble submission, if the trial would produce, kindly have the pleasure to see what the CBI has submitted before the
your
court
prayer
below.
is for calling for documents under section 91
Yes, my lord.
before framing of charges. That from your I have not gone through the case.
Yes, my lord. I would only submit not one thing for my lord's lord. My learned friend has what he has submitted, that even the CBI is not in accession of that, lord. If the lordship, there is an accusation against me, grave accusations, they say that he has no access to the papers.
No.
And that is made a basis of lord.
What I understand,
Lordship,
the charges will be considered on the basis of available documents which the IO has filed along with his police report 173 report.
lordship, they have only given annexure, lord, and they have not produced any material on record, lord. I am only submitting that what is the material on record. Kindly give me a copy of that to which they say, lord, that I don't have even control of that. I cannot access it. The CBI says so, lord.
So prosecution is not relying on those documents.
They are relying on the document without material, only putting an annexure, lord. What was the conversation? What was the discussion? Lord, I just wanted to have a copy as to whether the prerequisite condition of section 5 and the corresponding rule 419A, lord, is satisfied or not. My lord, I have a very limited submission, lord, today before my lords, as to whether these prerequisites are satisfied. Nothing more. If the prerequisites are satisfied, lord, then I will have no case. That is what precisely, my learned friend may answer that, lord. That is what precisely I would submit with humility before my lords, lord.
Yes, miss. Anything.
My lords will kindly see what I have submitted
You
is
are
recorded.
You are impugning which order? 13.5.
Yes, lord, page 34, 13.5. Yes, lord. My lord will see, if at all my lord will permit me. As
At what stage the trial is pending? The consideration of charges. What is the next date fix?
16th of July, lord, as I understand.
Or after rejecting your prayer,
yes,
the next date is fixed for
16th of July.
For consideration of charges. For consideration.
That is not known to me, Lord.
A discharge is also filed. Yes. Lord, I would humbly submit, Lord, only one thing, Lord. They say that they are not in possession of document. They are only saying, let them file a counter affidavit, Lord.
No,
because they say, Lord will kindly see page 39. My Lord will see page 39, Lord.
No, we have to see whether the impugn order whereby your prayer for calling for certain documents under section 91 at the stage of consideration of charges is bad or good.
Yes.
That only that is the limited area.
Yes, Lord.
Now they cannot convince into the area whether the intercepted call are valid or invalid, Lordship, at this stage.
No, I am not on that, Lord.
Prayer is very
Maybe I stand corrected, Lord. I am not on that, Lord, at all. I only submit, Lord, as to whether they were in accordance with section 5 made with rule 1419 or not. I am only to that limited extent, Lord. They say, Lord, in page 39, they have what they have submitted before the court below, that they have no access. If they have no access, Lord, what do you produce? And I am being, what you call, dragged into a criminal prosecution, Lord. I would submit, Lord. I'm only on limited aspect of compliance of section 5 read with rule 419 capital A, my lord, nothing more. To that extent, they may clarify, my lord. I would only submit that, my lord.
No, that plea was not before the,
Yes, that is the plea, my lord. I would humbly submit, my lord. That is the only plea, my lord.
that plea you have not taken before.
My lord will see kindly, my lord. Because all they say that that was in accordance with the rule. That is what even the impugned order also mentions, my lord. That was in accordance with the rule.
Yes.
Lordship, what they are saying is that whether the procedure has been complied with or not, and the documents relating to the procedure, what Lordship, what is necessary, they are referring to section 5 of the Telegraph Act. Section 5 of the Telegraph Act says that only in case of public safety and on public emergency, one can intercept the call.
Yes.
There are public emergency and safety. Corruption cases are only in respect of public safety only, Lordship. The several decisions of our tax court, Lordship. And accordingly, it was intercepted. Now, what is section 419? 419 lays down the procedure.
419 of?
419A of Telegraph Act, Lordship. 419A of the Telegraph Act is a rule which was framed subsequently after the pronouncement of judgment of PUCL. PUCL judgment says that you'll have to follow certain guidelines. PUCL judgment of PUCL, it lays down certain guidelines to be followed while intercepting telephone calls. That judgment subsequently, at the same time, it was held that subject to formation of any rule by the parliament, that will be there.
Judgment will
prevail.
Now still that judgment is holding field.
No, Lordship.
Or
As because
some rules have been framed.
rules has been framed. That
In
is
that
for
rule also, I just want to know.
Yes.
Earlier, a high-level committee of the government.
Yes.
Used
Involved.
to
Yes,
be
sir.
involved,
Yes.
which used to scrutiny
Yes. Review
the
committee.
request of the government
Yes.
for such.
Certain rule, let me submit, Lordship. First rule is that the investigating authority, they will have to obtain a permission from the competent authority. And the competent authority is the Secretary, Home Department. If for public emergency, Lordship, and for operational reason, the director of the department can issue such order. Here in this case, perhaps the director has issued the order. And subsequently, if the order was obtained by the investigating authority, they can intercept. And subsequently, there are several other rules which says that review committee has to be constituted. The review committee consists of the Secretary, Home, and other department members of the other department. That rules are there. So now the rules, this review committee has been considered or not, that is not known to us, Lordship. We are the investigating department, Lordship. So now how can we obtain it?
No, this is what I see. The question before the court is
Lordship.
When this special judge is seized with the matter,
Lordship.
when you file the police report under 173, accused is summoned. The stage is of framing of charges.
Yes.
At the consideration of framing of charges.
Yes.
The court would consider all the documents which were sent to the court along with the police report only. Copies of those documents are given to the accused side.
Yes.
Now, whether at this stage,
Yes.
at the stage of consideration of charges,
Lordship.
whether accused can say that some more documents should be considered, which are not part of one's report.
Relied upon documents.
173.
Yes.
Yeah, relied upon.
This is not a.
If the prosecution side has not annexed those documents under 173 clause 2, whether you can say that you also bring that document.
No, I'm not asking that. They're relying on that, Lord.
No. We are
Let
not.
them say that they are not relying on those things.
No, no,
Lord.
let
No,
them.
Then I would
then
submit please
why-
one thing.
No, no, no.
Yes,
Please
Lord.
listen. Then why have you filed 91 CRPC petition when?
Lordship, my learned friend, Lord, I'm grateful to him. He has elaborated, Lord, the guidelines, the review committee and everything, Lord, read with the judgment of the Supreme Court. Now, if at all, Lord, section 5 and 419 rules have not been complied with, Lord, then the whole thing will be without jurisdiction.
No, why you are saying it is not complied with? There cannot be
They
a,
have to say, Lord, they have to
No,
say
they need
that
not-
it has been complied with.
where is such requirement? When a copy is, when the copies of documents are, which were annexed along with 173 report has been furnished to you.
Lord, they
If
are
you have
only
any,
annexures, Lord. They are only annexures. There are no
But-
documents, Lord. I am only wanting to see as to whether there are supporting material, Lord. I am only wanting a free trial, Lord, nothing more. So at least they must say, Lord, let them say at least in a counter affidavit, Lord, that, and bring on record at least that those compliance to the rules have been done.
no, you cannot compel the
No,
prosecution.
I cannot. I cannot. My
If-
Lord,
if their-
what I am
if
submitting,
their
Lord, is a
case is-
prayer before my Lord.
If their case is weak, you can take advantage at the time of,
Right.
but you cannot.
No, Lordship, I do not intend to do that. They are weak or I am very strong. I don't say that at all, Lord, with humility. What I am trying to submit, Lord, there is a statute. And the purpose is consideration of desirability or necessity. And unless what is the public emergency? How it is a public safety, Lord? And Lordship,
No, the
those
basic,
things would show definitely,
the basic question which perhaps I am not understanding,
Lordship.
that you make me understand.
Lordship, I would bow down, Lord. I would bow
The
down.
only limited question is when the prosecution has, along with its report, submitted before to the court after completion of investigation, has relied on certain documents. Can you also go beyond that, asking for certain more documents?
No, Lordship, let me, Lord, with humility clarify, Lord. I am not asking for any more document, Lord. I am only praying, Lord, that my learned friend on the other side, Lord,
No.
say that the statute has been complied with, Lord.
That
Let them say that, Lord, because that would render the proceeding without jurisdiction, Lord. That is a question of law, Lord, that would, Lord, fall for consideration before my Lord's, Lord. I would only beseech my Lord's, Lord, to Lord, ask my learned friend to file a counter affidavit, Lord. Nothing beyond. And
Yes,
my Lord
yes.
may consider that,
We
Lord.
are-
That
we
is
are-
my humble
we are-
prayer.
We are not bound to file any counter affidavit also, Lordship.
yes. If
Law
you-
is
No, no.
very, law is very simple, Lordship. Whether at the stage of charge, framing of the charge, whether they can compel us to file in such document.
that is the only
That is the
question.
only question, Lordship.
Ah.
Now,
Apart from oral, Lord, there is nothing on record. Lord. Apart from oral allegations, there is nothing on no material.
they'll get the
Then
benefit.
you same, Lord.
No,
If
then
there
you
is nothing, they'll
go,
be discharged.
then you take the benefit during charge hearing. If there is nothing, their case will fall. But you cannot compel the prosecution that you bring that also. We want to see that have you complied so and so rules or not.
They'll get the benefit, Lordship.
What should we do?
Lord,
It will be
section
disposed of,
91, Lord, was only to be looked into, Lord, the two words, necessity or desirability, Lord. And it is this court, Lord, only has to consider while considering a petition, Lord, 91. Lord, what I submit, Lord, with humility is that apart from pasting and the verbatim, Lord, section 91, Lord, there is no consideration of the desirability
Whether
or
any
the
record is to be
necessity.
looked into or orders are sufficient.
No, not required. Lordship.
Nothing at all, Lord. There is no whisper, Lord. That is what precisely is my submission, Lord. The only judgments, Lord, and the submissions, but no consideration. at all. Let them consider at least, Lord, my Lord may only direct them to consider, Lord, the learned court below, Lord.
Where is your petition?
Petition.
For 91.
Petition,
Lord-
they have not annexed, Lordship.
Yes, sir. My Lord is referring to the petition 91.
91 petition.
That is not verbatim considered, not in the order itself, in the impugned order itself.
No. But unless the petition is before us, how will you be considered?
I'll
But
bring that on
other-
record, Lord.
Lordship, even if
I'll
that
bring it on
petition is
record.
there, what would be their prayer there?
We will
They
see
have called
what-
for certain
Yes,
documents. That is
Yes.
their prayer.
That is I am assuming that is their limited prayer.
Yes.
Yes, sir.
And my understanding is you cannot ask for calling for
Yes,
certain
that is
documents.
the settlement
at the-
also. Even Devendra
Lords,
Pahil.
I would not, I bow down to
bring-
what my Lord, what's falling from my Lord's Lord. I am only submitting, Lord, at least my Lord in this jurisdiction can see him, Lord, as to whether there was a compliance of the statute or not.
No,
Cannot.
Only nothing
whether
beyond,
that
Lord.
requirement is there or not. Okay.
Lord, because my submission is not that if it is not complied with,
you
Lord,
bring your petition on record.
Lord, grateful,
File an additional affidavit.
Lord, grateful.
We are not issuing notice, nothing. No, only CBI is the
CBI is the only.
Yes,
party. Heard Mr.
DV Pati, Lord, PATH.
DV,
DV, D for Delhi, V for Victory, PATHY.
Mr. DV Pati, learned counsel for the petitioner. Also Mr. M. Halloway, learned standing counsel, CBI. Learned counsel for the petitioner submits that praise for allowing the petitioner to file an additional affidavit to bring on record certain, what do you want to bring on record?
Only as to whether there was a compliance of section 5
No,
of the
no.
Telegraph Act and the review.
No, what do you want to file?
I would find the petition under 91, Lord. What has fallen from my Lord's Lord?
The bring on record the petition filed by the bring on record the copy of petition number 1392/23 filed by the petitioner under section 91 of the CRPC in the Miss CBI case number 29/23 arising out of special case number 2/2022. When will you file?
Not during 2 weeks, I will do that. There is a vacation, Lord, I am told, Lord. After the vacation. After 1 week after the
The
vacation.
prayer is allowed. Let this case be listed. We will list this case again at motion, in the motion stage. Let this case be listed again in the motion stage. After 2 weeks. You want a fixed date?
If at all, Lordship, I come from outside, Lord.
Yes.
Grateful, Lord.
When would be?
So 2 weeks after vacation.
2 weeks after vacation, Lord. Or 1 week after vacation would do. If at all it's convenient to my Lord's Lord.
Okay. Then you don't want a fixed date.
Lordship.
Do you want
1
to
week
take-
after vacation, my
No,
Lord
no,
will
no,
fix
you-
a date, Lord. I would on that day be present, Lord.
Any date after 1 week after.
1 week after vacation, Lord.
Any,
Lordship.
he is asking
30.
for any date in 1 week after the vacation.
30,
30. As your Lordship.
30 July.
Lordship. Grateful.
And
Yes.
before this.
Lordship, let it be on 31st, Lordship.
31st,
Already fixed. July, no? 31st. Lordship.
31st July.
31st July.
There is an accounting day, my Lord, that it will be on 1st or 2nd of August if it is convenient.
yes.
Okay,
Yes,
second,
yes.
2nd of August.
Lordship.
2nd of August.
Lordship. Grateful. I'm grateful.
Hello.
Then let it come.
Because
Okay,
16th
okay,
July is
motion
16th is the date, Lord, before that court, Lord. If I could get only protection, Lord, till that my Lord is considering it.
No, not at this stage. Therefore, I was suggesting let it come before 16. no
I
intelligence.
have no difficulty, my lord. Yeah, I have no difficulty, my lord, if it's convenient to my learned friend, my lord.
Which
Uh,
date? do you want?
16th of July. There.
16th of July.
Yes.
Yes, it can be done.
My lord was fixing 13th
16th
earlier.
of July.
No, 16th is the date below, in the
Code below.
report below.
Good below.
So
Let it be on 15th,
15 July.
15 July.
15 July.
15 July.
Immediately after your opinion.
my lord is saying that.
15 July.
Then 15th, lord. Convenient to my lord's lord. So I'm grateful. And to my learned friend.
Lordship, I'm
15
let
July.
it be on 15th.
Yes, Mr. Putul, call this.
Grateful, lord.
May I please, your lordship? Lordship, this criminal petition has arisen against the NBWA and PNA issued by the learned additional CGM Nalbari. My lord, the petitioner hails from Manipur and the jurisdictional court is in Nalbari. So, though at the initial stage he had appeared before the court, but later on he had lost the contact with his advocate and gets counsel. My lord, I must submit that from the record, though the conduct seems to be not good, but for the hands of justice, my lord, that was not willful. That non-appearance was not willful, my lord. That's why my lord may give a chance that the petitioner will appear before the court in every date, my lord. My lord may impose any condition, my lord.
Which order you are impugning?
My lord, 16, 8.
Page
6/8/2016, page 21, my lord. And 26/5/2017, page 24. 6/8/2016, NBW was issued at page 21, my lord.
No, if you are not, your conduct is not proper, why should you get benefit from this court?
My lord, it's not willful, my lord.
No.
That's
how-
why, though
how-
it seems to be not good, my lord, but my humble prayer before your lordship is
But
that
if you knew the dates, how you can say that it is not?
my lord may impose any condition, my lord.
Will impose costs.
My lord,
And this
may
is
not
a
be,
long
you will
pending
appear
case,
in
my lord.
every day, my lord. Every day you
Since
will appear.
2015, my lord, not a single day he appeared before the court. And last date also, it was 21/6/24, my lord. On that day also, he didn't appear.
My lord, already I have submitted, my lord. He had lost his contact with his earlier engaged counsel because he hails from Manipur. So it's very inconvenient for him to come to Nalbari also. But now he has submitted.
No, but that you have failed to justify apart from.
My lord, definitely, I cannot justify. I bow down to your lordship. But my lord, a
You are-
last chance may be given, my lord.
You are appearing for the respondent.
I'm from Custom Department, Special PP.
Okay. What is your submission?
My submission is since
This is item number 20?
19.
19, my lord.
19, okay. What is your submission?
Trial is going on, my lord, and he should appear before the court. If any chance he has been given, its strict conditions may be imposed. Because he has not appeared before the court, not a single day, my lord, since 2015.
Heard, Mr.
PM Deka.
BM Deka, learned counsel for the petitioner, also heard Miss
P.S. Chakrabarti,
P.S. Chakraborty, learned standing counsel, NCB,
SPP, Special Public Prosecutor,
learned special public prosecutor,
Custom Department.
Customs Department. This application under section 482 of the Code of Criminal Procedure, 1973 has been filed by the petitioner Muhammad Ziaur Rahman, alias Muhammad Ziaur Rahman, impugning the order dated 6/8/2016, 26/5/2017, and all subsequent orders whereby the additional Chief Judicial Magistrate Nalbari had issued the non-bailable warrant of arrest against the present petitioner and also issued orders for proclaiming the petitioner as an absconder and for attachment of his properties. Learned counsel for the petitioner submits that you earlier appeared.
Yes, my lord.
When
There is no record, my lord.
you make
Yeah,
your
definitely,
submission,
my
when you appeared.
My lord, we have appeared. I'll tell you.
Learned counsel for the petitioner submits that earlier he appeared before the Court of Learned Chief Judicial Magistrate in where the custom case number 16/CL/IMP/AS/GAU/14-15 is pending.
Now registered as CR case.
Corresponding to registered as CR case number 246/2015 is pending. However, he submits that as the petitioner is a resident of the state of Manipur, he lost contact with his engaged counsel. It is also submitted by learned counsel for the petitioner that the default by the petitioner was not willful default, and he is ready to face the trial and subject to any condition imposed by this court. On the other hand, learned Special Public Prosecutor Customs Department submits that bare perusal of the record would show that the conduct of the petitioner is not good and he has defaulted in appearing before the court since the year 2016.
Yes.
2016. Stop. I have considered the submissions made by learned counsel for both the sides. Though the conduct of the petitioner is not good so as to get a favorable order from this court. However, considering the fact that the petitioner is a resident of Manipur and considering the submissions made by learned counsel for the petitioner, he is allowed to appear before the trial court. When is the next date fixed?
My lord, 20th July.
On the before the trial court, that is the Court of Additional Chief Judicial Magistrate, Nalbari, on 20 July 2024, subject to payment of cost of rupees 5,000 to be deposited in the cost fund account of District Legal Services Authority, Nalbari.
Well,
the petitioner shall deposit the said costs before the Secretary, District Legal Services Authority, Nalbari, and after taking the receipt thereof, shall appear before the Court of Learned Additional Chief Judicial Magistrate, Nalbari, in CR case number 246/2015. Stop. To facilitate such appearance by the present petitioner, the non-bailable warrant of arrest issued against the present petitioner by the Court of Learned Chief Judicial Magistrate, Nalbari, shall be kept suspended till the
Next day.
next date, that is 20/7/2024. On his appearance before this learned Additional Chief Judicial Magistrate Nalbari, the petitioner may pray for any relief before the said court to which he is legally entitled to.
And also attachment may be suspended.
Attachment, nothing has been attached.
Yes. And
Your fear is of warrant only.
yes, and maybe directed the learned court below to allow the petitioner on go on bail, my lord.
No,
With-
you make prayer, I have mentioned.
Which a phrase bail.
No, I have mentioned you may make such prayer before the trial court. It will consider your prayer.
My lord, the apprehension is that it's a long pending case, so.
No, you show you take the certified copy of this order. If still your bail prayer is rejected, then options are available before you.
If it's possible, my lord,
No, no, it is not possible.
my lord,
Let the trial court
my
decide.
lord. Humbly obliged, my lord.
Yes.
Great pleasure, Lordship. And this is regarding a NBWA Lordship. And issued against the petitioner by the Sessions Court, Nagaon Lordship. And regarding a session case number 3/2016 Lordship. And NBW was issued on 21/1/2023 Lordship, and 8 subsequent date Lordship, it is in force Lordship.
Initially, summons were issued
Issued
as per law.
You have not appeared in person to summons.
Initially issued, thereafter, I have defaulted Lordship.
You appeared
Yeah, appeared.
and defaulted.
Defaulted Lordship.
Then why have you defaulted?
Because when annexed 2 document Lordship, kindly have a look, there is a criminal revision petition is pending before His Honorable Court Lordship. Challenging the Lordship, framing of charge by the Sessions Court Lordship. It is still pending, I have checked Lordship. And then because of that, well, sometimes due to communication gap with the learned advocate Lordship, we defaulted Lordship. Yeah. Because it was initially kept in abeyance versus the pending.
When the notice, when the summons was the
First order Lordship, page Lordship 27.
No, first order is page 22. Summons issued to Forest North. Issue summon to the accused person 8/1/21. Oh, translated the original. Acha, acha, acha.
at page,
Page 27, it's the original certified copy Lordship. In the first date Lordship, then we have 29/7/2016 Lordship, page 28 Lordship. First, we have informed the learned court below Lordship regarding the tendency of the criminal revision system. Lordship.
He was often on absent without step, with step. Thereafter, NBWs were issued. About with step, without step, report.
or in the revision petition, the proceeding of sessions case was kept in abeyance.
Fixed period Lordship.
That might have confused.
That might have, yes. This is 29/7 order.
Then thereafter,
Proceedings were kept in abeyance, yes.
then when the NBW were issued, by which order?
21/1/2044
Yes.
Lordship.
When it was revived,
Case 44 Lordship, 21/1/2023 Lordship. If his personal is absent without any step, issue NBW against him Lordship. And prior to that, it was 18/11/22, he was present Lordship.
page 44, NBW.
First order Lordship.
Before that, when were you present?
18/11/22, I was present Lordship. Page 43 Lordship, last order.
He was absent with steps.
Then what is your justification? Then you knew that the case is fixed. Then that revision part goes,
Lordship.
because after that you appeared.
Appeared Lordship. And I have mentioned categorically in paragraph number 5, that's of my petition, regarding that there is some miscommunication with the This is learned advocate, engage advocate lordship before the trial occurs. This is the only ground I have taken lordship because
Yes. Ms. Jahan.
Next
I
date
will
is
appeal, lordship.
16/5, next date is 18/7.
Heard Mr.
R. Pupon,
R. Fukun, learned counsel for the petitioner. Also heard Mrs. Jahan, learned additional public prosecutor. This application under section 482 of the Code of Criminal Procedure, 1973, has been filed by the petitioner impugning the order dated 21/1/2023. Subsequent orders passed thereafter till 16/5/2024, whereby the Court of Learned Session Judge Nagaon had issued warrant of arrest against the petitioner in sessions case number T within bracket T2 case sessions within bracket T2 case number 87 within bracket N/2016. Learned counsel for the petitioner has submitted that the petitioner is facing trial before the Court of Learned Session Judge in sessions case number in the aforementioned sessions case. However, in the year 2020, 2016, he preferred a criminal revision before this court. That is criminal revision petition 229/2019, 2016, whereby the proceeding of aforesaid sessions case was kept in abeyance. Later on, the stay was vacated and the petitioner received summons from the sessions court, Court of Session Judge Nagaon. However, it is submitted by learned counsel for the petitioner that, however, due to communication gap with his engaged counsel, the petitioner defaulted in appearing before the trial court on the date fixed for trial, that is on 21/1/2023, and the Court of Learned Session Judge had issued non-bailable warrant of arrest against him. Learned counsel for the petitioner has submitted that the next date of this sessions T2 case number 87N is fixed on 18/7. On 18/7.
That's 18/7.
18/7, and he is ready to face and ready to appear before the trial court and face trial, as well as to cooperate in the trial. It appears from record that the petitioner did preferred a criminal revision against an order passed by learned session judge in in sessions case number 87N/2016, wherein for a brief period of time the said sessions case was kept in abeyance. Stop. Considering the fact that the petitioner had communication gap with his engaged counsel, and also considering that the fact that he is now ready to cooperate in his trial, this criminal petition is disposed of with a direction to the petitioner to appear before the Court of Learned Session Judge Nagaon in sessions within bracket T2 case number 87 within bracket 9/2016 on the next date fixed before the said court, that is on 18/7/2024, to facilitate such an appearance before by the above named petitioner before the trial court. The operation of non-bailable warrant of arrest issued against the present petitioner by the trial court shall remain suspended till 18/7/2024. On his appearance before the trial court, the petitioner may seek any relief to which he is legally entitled to. With above observation, this criminal petition is dismissed.
The typed copy, Lordship. Page 20, Lordship. The typed copy. May I read it, Lordship?
What is this?
Lordship, page 20 is the typed copy of the complaint petition.
No, what is your ground for quashing?
Lordship. Well, Lordship, if your Lordship kindly peruses the complaint petition, may I read it, Lordship, for a moment?
Yes. Now you come to the point.
Lordship, the allegations in the, as I have understood, the allegation in the complaint petition is that the respondent number 2 had married the daughter of the petitioner number 1.
Okay.
And Lordship,
Respondent number 2 has married the daughter of
the petitioner number 1. And accordingly, the daughter of the petitioner 1 was residing with him. Subsequently, the petitioner number 1 and the other petitioner went to his house and brought back his wife. And thereafter, the respondent number 2 again went back to his purported in-laws house to bring back his wife, where he was assaulted and sent back. And hence, he has lodged this complaint, Lordship.
So, under 343/506.
Lordship, now the
323 as well.
323.
And the cognizance order is, what is it?
Lordship will kindly see the cognizance order. That is at page 25.
Hmm.
Cognizance has been taken under 403 and 406.
Acha.
Read with 34 of IPC. Page 25, Lordship.
Criminal breach of trust.
Criminal breach of trust and criminal misappropriation of property. Now, Lordship, these sections in my humble submission are not even remotely attracted in the present case.
It was, there is no allegation.
There is no allegation of that. And the most interesting part is, Lordship, subsequently I have annexed all the orders. After having taken cognizance in the 403 and 406, Lordship, the next order is at page 26. Therein there is no mention of any section. Thereafter, Lordship, on
There
page
is no
20,
mention of what?
Lordship, page 26, this service has not returned. That is ordered at 4th of March 2024. The order next to the date of the cognizance order.
Okay.
Subsequently, Lordship, on the next date, that is on 22/4/24, page 28.
Yes.
Here, Lordship, the petitioners had appeared. Here, the learned court below observes, your Lordship will kindly see, fifth, the bottom paragraph, Lordship. Upon perusal of the case record, it is seen that cognizance of the offence has been taken against the accused persons under sections 343, 506, 323, with section 34. Now, Lordship, cognizance order is completely different. Cognizance has not been taken under these sections. These were the sections mentioned by the respondent number to the complainant in his complaint petition. But court had not taken cognizance under these sections.
Which court?
Lordship, the Court of the Learned Judicial Magistrate First Class, Morigao.
So the cognizance taking order is
Completely different, but cognizance has been taken under 403 and 406.
okay.
Page
then
25.
Now what is your submission?
Now, Lordship, my submission is that, Lordship, the sections under which cognizance has been taken, there is no allegation of those offences in the complaint petition. Those are not even remotely attracted in this present case, in my humble submission. Therefore, the cognizance order is not sustainable, and even otherwise, Lordship, this case has a background to it. The daughter of the petitioner number 1 was kidnapped. We had lodged an FIR. Those are all on record. Subsequently, police had recovered her. A final report was filed. My daughter was returned to me. Now, this thing of marriage, that also my daughter has submitted an affidavit that while he was undertaken by the complainant, by force, he had forced the daughter of the petitioner number 1 to execute a marriage deed. And that also she has signed on affidavit. That is at Lordship page 36. And on the day of the alleged occurrence, the petitioner number 1 is a grade 4 employee in the Director of Higher Secondary Education. He had attended the office. Attendance sheets are also there.
No, on facts, whether 482.
Should understand. But the primary ground is cognizance having taken another 403
That is the
406.
defect.
Subsequently, without there being any order, that could not have been altered in this manner. And the sections
No,
under which cognizance
subsequent also cognizance can be taken.
it can be taken, but it says
It
Lordship.
is not yet taken.
No, it says Lordship from the records, it is seen that cognizance was taken under this section. That is the language used. Your Lordship, if your Lordship kindly takes up the order, page 28, it says, peruse the case record upon perusal of the
Okay,
case.
what to do? Yes.
In fact, the ingredients, of course, the cognizance order was taken under 403 and 406. Criminal breach of trust might
It
come.
is not there.
But then what he said that they had taken his wife, he went there, he was assaulted, of course, assaulted part goes. And then he did not return, they did not return his wife to him. And
Now, at what stage the case is pending?
Lordship, we had appeared, we have been allowed to go on PR bond. On the last occasion, the complainant has not appeared. Now it has been again fixed on 5th of July. All the petitioners have appeared, but
facts are not very clear. There can be something more to what is being projected.
Lordship, then notice may be issued at least to the other side, let them appear. But till then, the further proceedings may be stayed.
No, why to give stay?
Lordship, because cognizance being taken, and Lordship, your Lordship will kindly say, I could have understood if subsequently cognizance was taken under this section.
Now court can take cognizance.
It can, but your Lordship will kindly see the order, page 28. It says that cognizance was taken under 343/506.
That
That
language
in
may
my humble submission is
That is a mistake committed by the magistrate.
can be a mistake.
That is
Even
apparently a mistake.
Lordship.
Even
That
in
may be a
s-
mistake. We don't know what.
Lordship, but even otherwise, Lordship, there is, because this is completely an act of vengeance against, because my daughter was recovered by the police, returned to me. My daughter was all along staying with me.
Okay, let the other side appear.
Lordship, but till
then
then,
Lordship
Lordship,
will consider on interim.
because the next date is 5th of July, the charge is framed, Lordship, then
Charge,
only
they
till the
have
next
to-
date, Lordship, the further proceedings may be said. Let him appear, and thereafter your Lordship will decide whether to extend the protection or not. But at least till the next date, Lordship, protection may be granted to the petitions. And Lordship, the petitioner number 1, he was instead in his office, and that has been given by the Director of Secondary Education, that he had attended office on that day.
Heard Mr. MP Sharma.
And A. Chakraborty.
Heard Mr. A. Chakraborty, learned counsel for the petitioner. Also heard Ms. S. Jahan, learned additional public prosecutor. This application under section 482 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Rafiqul Islam, impugning the order dated 12/1/2024 passed by the complainant, passed by the learned Judicial Magistrate First Class Morigao in complaint 9/2024, whereby the cognizance of offense against the present petitioner was taken under section 403/406/34 of the Indian Penal Code on the basis of a complaint filed by the respondent number 3. Learned counsel for the petitioner has submitted that though no allegation of any offense under section 406 or 403 was made in the complaint filed by the respondent number 2, the court wrongly took the learned Judicial Magistrate First Class Morigao wrongly took the cognizance under section 403/406/34 of the Indian Penal Code. Stop. It appears it is also submitted by learned counsel for the petitioner that the respondent number 2 has categorically stated in the complaint petition that the offense alleged by him were against the present petitioner were under section 343/506/323/34 of the Indian Penal Code, for which there is no order of the learned magistrate in the said case which shows that any cognizance of the said offences were taken by the learned magistrate. Issue notice to the respondents. Since learned additional public prosecutor has appeared for respondent number 1, no formal notice need to be issued to respondent number 1. There are many petitioners. Petitioner plural of time. Or
Five in total.
5 petitions.
All are family members.
However, as regards respondent number 2 is concerned, the petitioners shall take steps for issuance of notice on respondent number 2 by registered post with AD within 3 days from the date of this order, returnable on 31 July 2024. In the meanwhile, from the documents annexed along with the complaint petition, along with the criminal petition by the petitioners, including the copy of complaint filed by the respondent number 2, it appears that no allegation under section 406/403 was made against the present petitioner on the said complaint. Hence, the further proceeding of complaint case number 39/2024 pending in the Court of Learned Judicial Magistrate First Class Morigao shall be kept in abeyance till the next returnable date.
Much of it.
List according.
Much of it. Met with your lordship. 438 application lordship. Here in this case, lordship has granted 2 accused persons bail, one during investigation, one after charges. Lordship may kindly turn to page 15 of my petition lordship.
Page 15.
Page 15, 1/5.
Yes.
This is the person of
This order was sought after submission of charge sheet. I am on similar footing, so I am also not named in the FIR. FIR is at page 13.
Who are you?
I am also related to one person. He is also granted bail, that Moinul Haq. That order your lordship will find page 23. He is my uncle.
You are not involved in the
Not
that-
involved in
that
the offense. I was-
hospital.
Yes, please paragraph 4 lordship may kindly see of my petition. Paragraph 4.
Yes.
Because of that reason, they suspect that I was also involved.
Heard, Mr. No, now whether police is searching you.
Already charge sheet is submitted, and because of it, that 313
Charge
is
sheet?
there. Charge sheet is submitted
Against you.
against me, and page 15 that total 8 persons are named, and page 15 your lordship will find one person, and
Then you
myself was
appear
shown as
before the
trial
trial.
court. Some protection that may be granted. Lordship as page 15, your lordship has protected.
No. Whether any warrant has been issued against you.
No, someone was.
Then where is the,
Because lordship 313 is there. Lordship may kindly see it.
what is the punishment? Life?
Yes. That is there. Page 18, paragraph 9.
Heard,
lordship may
Mr. A. Ahmed, learned counsel for the petitioner. Also heard Ms. N. Das, learned additional public prosecutor. This application under section 438 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Jinnatul Ali, who is apprehending that he may be detained, he may be remanded to custody in connection with ARC case number 189/2024, which is presently pending before the Court of London Additional Chief Judicial Magistrate, Morrigaon, if he appears before the said court. Stop. Learned counsel for the petitioner has submitted that in the aforesaid case, that is PRC case number 89/2024, charge sheet has been laid under section 120B/4. Under these sections, charge sheet has been laid.
Lordship. That is page 16, paragraph 4, lordship will find. Page 16, paragraph 4.
Charge sheet has been laid, and the Court of London Additional Judicial Magistrate, Additional Chief Judicial Magistrate Morrigaon, took cognizance of offense under section 120B/419/425/468/471/270/313/326 of the Indian Penal Code against how many accused persons?
8 persons.
Against 8 accused persons, including the present petitioner. It is submitted by learned counsel for the petitioner that the name of the, though your name is shown as,
That's correct.
though the name of the present petitioner has been shown as an absconder in the charge sheet, however, and though the learned committal court has issued summons to the present petitioner, however, as the cognizance of offense has also been taken, inter alia, under section 313 of the Indian Penal Code, for which the maximum punishment prescribed is
Life imprisonment.
life imprisonment, and hence he submits that for the committal court, which is the court of which is the court of learned additional chief judicial magistrate, the embargo of section
For 437.
437
subclause
clause
1, subclause 2.
clause 1
Subclause 2.
subclause 2 Roman 2 would be applicable, and the committal court may not grant bail to him even if he appears in compliance to the summons received by him. It is also submitted that under such circumstances, the committal court would be left with no other option but to remand him to custody on his appearance. Stop. The learned counsels for the petitioner has also submitted that the petitioner's name has been implicated in this case only because he happens to be nephew of one of the co-accused, namely
Moinul Haq, Mohammad Moinul Haq.
Mohammad Moinul Haq. Learned counsel for the petitioner has also submitted that in the meanwhile, few of the, how many have been released on bail?
I have knowledge about 2 persons, sir. Page 15 and 22.
Two of the co-accused are already released on bail by this court. Stop. Anything? Let him appear. Considering the submission, I have heard Ms. N. Das also, Ms. N. Das, learned additional public prosecutor also, and peruse the documents annexed along with the anticipatory bail application. It appears that the PRC case number 189/2024 is presently pending before the Court of Learned Additional Chief Judicial Magistrate Morrigaon, and said court has already taken cognizance of the offense on the basis of various offenses, including the offense under section 313 of the Indian Penal Code, for which the maximum punishment is life imprisonment. And therefore, it appears that the submissions made by learned counsel and the apprehension of the petitioner that he may be remanded to custody even if he appears before the learned committal court appears to be genuine. In view of above, when is the next date?
Next is 15/7/2024.
In view of above, this anticipatory bail application is disposed of. In view of above, disposed of with a direction that the petitioner shall appear before the Court of Learned Additional Chief Judicial Magistrate Morrigaon on the next date fixed, that is 15/7/2024, and on such appearance, he shall be allowed to go on bail of ₹30,000 with one surety of like amount, subject to the satisfaction of learned Chief Judicial Magistrate Morrigaon, with following condition: cooperation in trial. With above observation, this anticipatory bail application is disposed of.
May I please, Your Worship?
Oh, yes,
My lord, for 38 bail application, my lord, FIR is press 9, my lord. Section 8 of POXO is less.
POXO is there.
Yes, my lord. Section 8 is there.
Mr. Bodjo,
My lord.
the NCB council made, yes, now you make your submission.
Yes, my lord.
She
Correct,
made
my
it.
lord.
Then I cannot pass orders.
Yes, but because that was done at the very earliest stage prior to charge. However, my lord, as in view of the notification which exists, my lord, notification number 18, with regard to my lord bail application with prior rejection, maybe my lord the intermediate order which I have annexed, maybe at that time the honorable bench was not available, my lord. But now, my lord, I think my learned friend is correct, my lord. I'll obtain instructions and bring the first rejection order which my learned friend is mentioning on record. And then, my lord, raised may place the matter.
Before which court?
Before, my lord, as your lordship deems fit, because my lord, earlier rejection, that
No.
bench is presently not available. However, my lord, the order which my learned friend is referring to, that
Yes.
honorable bench is available, my lord.
Then registry will decide before which bench it will go.
Yes, my
Will
lord. If it
will
is
not pass
before,
orders.
then lordship, yes, my lord. And in the meantime, I will also file an additional affidavit. my lord.
Okay. Heard, Miss,
M. Deka.
though heard Miss
M. Deka.
M. Deka, learned no, heard Mr. D.K. Bodjo, learned counsel for the petitioner, as well as Miss M. Deka, learned counsel for NCB. Though this case was fixed for delivery of orders today, however, before the delivery of the orders, Miss M. Deka, learned additional public learned counsel for NCB, has made a mention to the effect that that the petitioners in this case had preferred a bail on earlier occasion, which was rejected by a coordinate bench of this court, within bracket, Honorable Mr. Justice K.R. Surana, bracket close, and hence, as per the standing notification of the registry, this bail application should be considered by the said court. In view of submissions made by learned counsel for the NCB, let the registry list the matter before the appropriate bench.
My lord, it will be allowed to file the additional affidavit, my lord, to bring it on.
Stop. Learned Mr. D.K. Bodjo, learned counsel for the petitioner, praise for allowing the petitioner to file an additional affidavit. Same is allowed.
Lordship, there is correction, Lordship. This is custom matter.
Instead of NCB, customs.
Deeply obliged.
This is previous bail application, lordship. Lordship will find the affair at page 8.
Yes.
Lordship, the previous bail application affair at page 8, lordship. Allegation under section 366 and 4, lordship. The two accused person, lordship. Here the petitioner.
Case is that, my lord, this ACB, my lord, one company, my lord, they have invited that the procurement of the vehicles. The committee was formed. In that committee, two bidders submitted their bid, my lord. One bidder was accepted, other bidder was rejected. Subsequently, it came to know that the bidder who was successful, he has submitted some false document.
False document.
False document. So subsequently it was there. Then in the meantime, 50% payment was made to him. He came through this honorable court. This honorable accepted his 50%, saying that liberty is given to the department to pay the rest amount fine. This is also, it is annexed matter. Now, so far the present petitioner concerned, he was a member of the evolution committee.
Who verified the It is
that
bid
if there is anything irregularity may be done, my lord. What the community now case is registered, your lord kindly 406, 409, 419, 420, 468.
You are named in the FIR.
FIR name here. Your lord kindly say FIR, my lord. Page 15. FIR name your lord, not I along my lord, page 17, to the 8-person name. In the meantime, inquiry was made. I was asked to appear before the director of vigilance. I appeared. My statement is recorded also, my lord.
Your statement recorded.
Yes, my lord. Your lordship, I made a statement. Your lordship will find page 18 is a notice issued to me, page 18, to explain some points they have raised in paragraph in page 19 by my forest department. Your lordship, on page 18, my name, I was this notice, your lordship got it.
No, but this notice is by some
By
department.
the department, asking me, page 19, your lordship, find middle person, in this regard, you may please state, page 19, your lordship got it, fine.
Yes.
Whether you were physically present in the meeting on science, please specify on which date you actually signed on the pages, whether you signed the minutes, whether you were present on the day. May please specify at what time the committee meeting was held, whether you signed the minutes. If you signed the minutes, then specify the reasons thereof. May please specify in the meeting committee for BWSN was actually held on so and so and so and so. I replied all this thing. My reply is page 25. Details reply I have given. Page 25. Your worship, all the points I have replied. First, in the first line, my lord, first page 25. Where is the community, my lord? I am only on that, my lord. Where is my custodial interactions required? What community, my lord? How it prevention of corruption comes?
This reply is in connection with some departmental.
The department. This department is the main authority, my lord. They have given to a company. Company invited, my lord, that the tender. Tender submitted by 2 persons. One of them might have committed some irregularity, my lord. Also, for the you take against him, you cancel that. I have nothing to do, my.
What is alleged against you?
My lord?
In the FIR, what has been alleged against you?
Yes. In the affair, basically, anomalies that they have stated regarding. It is suspected, page 15, your lordship. Page 15, 1-5. Photo. Page 1-5.
Yes.
It is suspected that anomalies and illegalities had occurred in the process of tendering and procurement of vehicles. One Sabadalam Bordersker, I am not, my lord, attended the bid opening and signed on behalf of the SPL company, my lord, the company which got the award. Although he was not authorized representative of so and so. Thereafter, my lord, he was absent on the date of bid opening so and so, so and so, so and so. Then the then PDFD named Sri KP Jadhav, Pavan Kumar sought 4 additional documents from SPL knowledge. Then 4th line, there were discrepancies found in the date of document. SPL knowledge service had also submitted experience certificate from the State Bank of India. That was not found to be not correct, my lord, in supplying vehicles. However, SBI had not issued the experience certificate submitted by SPL knowledge of service. Supplier. I am not, my lord. So he has submitted some false document. Subsequently, it was detected false. That is now pending before the Honorable Court, my subject before the Honorable Court. Thereafter, my SPL knowledge service in the financial bid so and so, development surrounding the speeches of so and so. Now, so far the present petitioner is concerned, no, it is suspicious, your lordship got it.
Where?
Page 16, last but 1 paragraph. This is what I find. In my account, some money was found.
Where?
Suspicious cash deposit, your lordship. Last but 1 paragraph.
Yes.
Suspicious.
You are Abdul Wahid.
My lord?
You are Abdul Wahid.
Yes.
Yeah, I am Abdullah. Now I have been terminated also, my lord. Because of this, my service already I am terminated. That is also annexed, my lord. So in my account, money is there. My wife is also your service money employee. Money is there. I will explain why this money is there, my lord. You cannot connect it to that, my lord, that one, my lord. That one is not cumulative, my lord. That irregular procurement of contract. And total, how many percent you will page 17, you also will see. Page 17. All the persons who are members of the committee are the made accused.
This is bid evaluation committee.
Bid evaluation.
Yes.
My lord, here specific allegation is here, my lord. And so he was the member of the bid evaluation committee, and it was those money transaction, because it was doubted that, my lord, the bid
Suspicion is
evaluation committee members were,
Suspicion.
yes, my suspicion. And my lord, he gave the explanation, those are not satisfactory. Then this FIR was lost, my lord.
But in FIR, some accusation has to be there.
Yes,
Some,
my lord.
what is
My
the,
lord, after that, my lord, it is suspected that, my lord, because this is a, my lord, process which has to be investigated by the police, my lord.
it is suspected that has been alleged in conspiracy. Yeah.
All documented, my lord. Documented evidence.
And the amount of money involved is huge.
Money, who has taken the money?
That is under, that will be investigated, my lord.
Supplier, he may be made liable, money. If it is found that you cancel his bid by the department. Now, I am a member of the committee, my lord. How I can be held responsible for that one, my lord? How can I know that it is full document unless now it has come to the light? That will be inquired into and then finally with that one. So my prayer is, at this stage, custody interrogation not at all required.
My lord, kindly peruse page 20. These are the allegations against him. Being a
Page?
20.
Yes.
It was page 19, which is, I have already
Page
stated.
20. What is?
These are the detailed allegations against him, showing his involvement.
So beads are also found to be free from fraudulent. On
That
preliminary
he
examination,
signed. These are subject. No, this, at page 20, these are the findings during inquiry,
Yes.
departmental inquiry.
yes. The tools I have replied also.
Finding some, my lord, allegation because they showing his involvement, my lord.
But where is the criminality? That is the question raised by the
This
others.
is only thing.
The criminality
Let
because-
let him appear. You need his custodial detention.
And because the amount of money is very huge, my lord.
No, what
Because
money
he
is?
may involve, he may also influence the, because he was a member
No,
of the bid evaluation
No, I
committee.
want to understand. What is the allegation? You are only suspecting that
Yes, that is true, my lord. Here it is
you have
written as
not even
suspected.
alleged that this much money he has taken.
Yes.
The amount of money in the contract may be huge. That is the bidder and the department.
Because the bidder in connivance with these people.
Now, what allegation is there against the present petitioner?
My lord, here this
FIR shows that suspicion is there which needs to be investigated. Let it be investigated. Let him cooperate.
Yes, one.
Heard, Mr. H.R.A. Chaudhary, learned senior counsel assisted by Mr. M.J. Kadir, learned counsel for the petitioner. Also heard Mr. R.R. Kaushik, learned additional public prosecutor. This application under section 438 of the Code of Criminal Procedure, 1973 has been filed by the petitioner Abdul Wahid Chaudhary, who is apprehending his arrest in connection with ACB PS case number 24/2024 under section 120B/406/409/420/468/471 of the Indian Penal Code, read with section 7 within bracket A, small a, comma 13 within bracket 2 and 13 within bracket 1 within bracket small a of the Prevention of Corruption Act 1980. The gist of accusation in this case is that one, on 16/3/2024, one Barun Purkayastha, Director IPS SP of the Directorate of Vigilance and Anti-Corruption, had lodged an FIR before the officer in charge of Anti-Corruption Branch Police Station, inter alia alleging that during regular inquiry initiated by the Directorate at the instance of government of Assam regarding the allegation of anomalies in procurement contract relating to procurement of vehicles under Assam project on forest biodiversity conservation phase 2. It was suspected that some anomalies and illegalities had occurred in the process of tendering and procurement of vehicle. In the FIR, it was also suspected that it was also alleged that some suspicious cash deposits were noticed in the bank account of the present petitioner, who is the procurement specialist of the Assam project on forest and biodiversity conservation society. Learned counsel for the petitioner has submitted that the main allegation in the FIR is one of the bidder, namely SBL Knowledge Service Private Limited, against whom the allegation is of depositing forged documents and also of bribery, cheating, and forgery of documents. Learned senior counsel for the petitioner has submitted that the present petitioner was one of the member of the bid evaluation committee and he has been implicated in this case only because of his status, because he was the member of the bid evaluation committee. It is also submitted that in the meanwhile, certain Principal Chief Conservator of Forests and Head of the Forest Force Assam had issued notice to the petitioner No, what is your name?
Wahid Chaudhary.
A.W. Chaudhary, to the petitioner on 4th December, leveling certain allegations and queries against the present petitioner, to which the petitioner has answered. Learned counsel, senior counsel for the petitioner submits that the petitioner is ready to cooperate in his trial, and as there is no element of criminality in the allegations made against the petitioner, except the suspicion of except the allegation of suspicious cash deposit, which is also not specific, comma, the custodial detention of the petitioner may not be necessary, and he may be allowed to cooperate in the investigation. On the other hand, learned additional public prosecutor submits that perusal of the case diary would be necessary for consideration of the instant anticipatory bail application, as it involves huge quantity of public money from public exchequer.
It appears there is some material against him.
And he also submit, you are opposing the interim bail. He also opposes the interim bail of the petitioner on the ground that prima facie there appears to be material against the present petitioner. I have considered the submissions made by learned counsel for both the sides. Perusal of the case diary would be necessary for consideration of the instant bail application, hence call for the case diary. Fixing 22/7 for case diary.
But can it be on 27th?
27/7 for case diary. However, considering the fact that the petitioner has been involved, has been roped in the FIR, mainly because he was one of the member of the bid evaluation committee, and mainly because of due to some suspicious transaction in his bank account, which may bank account, comma, and comma, at this stage, his custodial detention does not appear to be necessary if he cooperates in the investigation. Hence, in interim, the petitioner is directed to appear before the investigating officer of ACB PS case number 24/2024 within a period of 10 days from the date of this order and cooperate in investigation. If he does so within the stipulated period of time, comma, in the event of his arrest in connection with the ACB case number 24/2024, comma, the above named petitioner shall be allowed to go on interim bail of rupees 30,000 with one surety of like above, subject to the satisfaction of the arresting authority. List this case on 27. 26.
26/7.
Hello, check. 1, 2, 3, check.
Item 61.
May I see the lordship, my lord? I will press the IA, my lord, because my lord, the appeal is fixed for my lord, hearing in usual course, my lord.
Appeal is admitted.
My lord, 4 years punishment, my lord, under section 8. RI, my lord.
IA call asle main case consider.
IA.
IA
For IA, my lord, the case is fixed today, my consideration of the IA, my lord.
But it is listed in hearing column.
Yes, my lord. IA, my lord, page number 8 is the, my lord, in the IA. For may I copy the, my lord, appeal, because in the appeal, memo of appeal, my lord, I have annexed the, my lord, statements, my lord, evidence, my lord. So, my lord, your lordship may take the memo of appeal, my lord, where I have annexed the, my lord, the statements, my lord. 4 years punishment, my lord, RI, my lord, page number 13, my lord, is the judgment, my lord.
13 of IA.
My lord, I will go to the memo of appeal, my lord, because in the memo of appeal, the evidence is also annexed, my lord. Statement of the so, my lord, page number 13 of the memo of appeal, my lord.
Yes. Yes.
My lord, judgment is, my lord, page number, order is page number 29, my lord.
What is your submission?
My submission is, my lord, based, my lord, for consideration of the, my lord, for consideration of the IA, my lord, I will base my submission, my lord.
No, we are considering your IA. What is your submission in IA?
In submission, my lord, I have gone through the, my lord, depositions, my lord, where, my lord, it is found that, my lord, this conviction is, my lord, not guilty is good beyond the reasonable doubt, my lord. My lord, I will bring your lordship's attention, my lord. It is alleged that, my lord, the petitioner.
You point out one contradiction.
Yes, my lord.
Glaring contradiction.
One contradiction is, my lord, page number 44, the victim.
Page number 44 of IA or
of the, my lord, memo of appeal, my lord. The victim is a, my lord, 12-year-old girl at the time of incident, my lord. And the petitioner is a 31 years old married person, my lord, adjacent to the petitioner's, my lord, the house of the, my
page
lord,
number?
Page number 44, my lord.
Yes.
Yes.
You come to the point, come to the point.
Yes, my lord.
You have not yet stated what is your point.
Yes, my lord. The first point, my lord, it is, my lord, stated, page number 44, my lord. My lord, accordingly, I went to the house of my cousin Fazila, and after taking chili from the house of Fazila, while I was returning to the matrimonial house of my elder sister Farida Parveen, on the way, accused Abu Siddiq, the petitioner, my lord, was available in the paddy field, and all of a sudden, accused Abu Siddiq touched on my breast and made attempt to commit rape on me. That is the allegation, my lord. Now your lordship will find, my lord, page number 46.
Yes.
My lord, the FIR is at page 16, my lord. My lord, the petitioners before your lordship are, my lord, the president and general secretary of all Bodo Student Union, my lord, Kosugao Anshalik Unit, my lord, and the informant, my lord, from one political party, my lord, Bodoland People's Front. My lord, alleged incident had taken place, my lord, in the wake of the last parliamentary election, my lord, 7th of May, after 7th of May, my lord. May I read the FIR, my lord?
No, whether Mr. Gogoi,
Lordship,
whether the petitioner, there is anything against the petitioner
that my lord, 365 and my lord, 3.
against the present petitioner.
Yes, so that is
Rinkang Doinari and
section, my lord, 365, 323. That injury report is there, my lord. No injury. That is no any external bleeding.
And what is the statement against the present petitioners?
Statement, my lord, they say that they were, my lord, confined in a room, my lord. They are
By
beaten
whom? By whom?
by these 2%, my lord, present petitioner.
Except 365, my lord, all other sections are available, my lord.
65, that is some other meaning. 342, it may be, my lord.
Allegations,
Okay,
and,
heard Mr. S. Rabha, learned counsel, S.R. Rabha, learned counsel for the petitioner. Also heard Mr. B.B. Gogoi, learned additional public prosecutor. This application under section 438 of the Code of Criminal Procedure, 1973, has been filed by the petitioners, namely number 1, Rincong Doemari, and number 2, Jaiklong Pasumatari, who are apprehending their arrest in connection with Posugao PS case number 8/2024 under section 341/323/365/342/506/34 of the Indian Penal Code. The gist of accusation in this case is that on 14 May 2024, one Budhiram Brahma had lodged an FIR before the Kosugam police station, inter alia alleging that on the day of lodging the FIR, the informant was going to Kosugao market in his own motorcycle when two Bolero cars and one Alto car bearing car intercepted him, and people and the occupants of the said car assaulted him and threatened him. Later on, he was taken to the Kosukam Ansulik Apsu office and detained there by the petitioner number 1, who is the president of petitioner number 1 and petitioner number 2, who are the office bearer of all Bodo Students Union. Learned counsel for the petitioner has submitted that the allegations against the petitioners in the FIR are not true. The incident happened during the parliamentary election, which was held in the month of May 2024, and the FIR was lodged against the present petitioner only due to political rivalry. On the other hand, learned additional public prosecutor has produced the case diary of Kosugao PS case number 8/2024 and has submitted that the injury reports, which is available in the case diary, shows that the informant sustained no injury. He also submits that the investigating officer has, in the meanwhile, made substantial progress in the investigation. Though he also submits that there are some incriminating material under section 365 against the present petitioners. I have considered the submissions made by learned counsel for both the sides and have perused the materials available on record, including the case diary, which was produced by learned additional public prosecutor. Though there are some incriminating materials against the petitioners, above named petitioners. However, considering the fact that the injury reports reveals that the informant sustained no injury, and also considering the fact that the investigation has progressed fairly well, the custodial detention of the above named petitioners may not be necessary if they cooperate in the investigation. You are on interim, no?
No, my lord.
In view of above, both the above named petitioners are hereby directed to appear before the investigating officer of Kosugaon PS case number 8/2024 within a period of 10 days from the date of this order and cooperate in investigation. Stop. If they do so within the stipulated period of time, comma, in the event of their arrest in connection with Kosugaon PS case number 8/2024, comma, the above named petitioner shall be allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the arresting authority with following conditions, number 1 and number 2. With above observation, this anticipatory bail application is hereby disposed of.
Deeply obliged.
Item 59.
May I please your lordship? It is my humble submission before this royal court for the interest of justice to stay the proceedings which is going on before the season Golwar court, my lord. My lord, the actual brief fact is that the respondent 2 made an agreement with the petitioner, my lord. Petitioner, my lord, to sell a plot of land, 2 acres, something less as. On the consideration of rest, 30 lakhs. The 30 lakhs. The respondent 2 took money 15 lakhs. 15 lakhs. Took money 15 lakhs. And after the expiration of 1 month, the respondent 2 give the permission, self permission. Give the self permission. And after pretending the matter that this marriage is not, there is a dispute between our family, made an agreement by pressure with the husband of the petitioner. And give the petitioner only 8 lakhs rupees. 10 lakhs rupees even to pay. And the respondent 2 made check bounce, giving 30 lakhs rupees. 30 lakhs. Check bounce. To escape himself. Of the respondent 2. The respondent 2 to make himself escape from the criminal offense, he made a affair, my lord. This affair is Jalguri PS case 585 2016. GR case 81443, which is filed on 27 2016. My lord, before that, my lord, I appeared on 16 7.
Whether respondent number 2 has appeared.
Yes, my friend is appearing.
You are appearing. What is your submission?
Now they have filed this interlocutory application for stay of the proceeding. Since charge sheet has been filed, lordship, time of the case is established, lordship, let them appear before the learned court. And there.
No, they have filed this criminal petition for what?
Also, this matter may be listed for hearing, lordship.
Yes, the criminal.
My lord.
No, listen.
LCR is also required.
Listen. When the other side has appeared, instead of going for interlocutory petition we will dispose of the criminal petition finally.
Yes.
LCR is there. The other party is.
Any other day, not today, lordship.
Today it may not be possible.
Yes, lordship. Any date, lordship?
You choose a date, we will dispose of the criminal petition.
Yes, my lord. My lord, it is a story matter there. It is a story matter.
I will not hear your story now. what I am suggesting, you choose a date, we will dispose of the matter.
Date
You-
করো, sir,
Amicably, both of you choose a date. Because a you have filed a criminal petition where record was called, notice was issued.
My lord. Kindly see
No,
annexure E.
listen to me.
Not today, not today.
Listen to me. Other side has appeared. We can dispose of it when we can dispose of it finally. Why to go for interlocutory application? If you have a case, it will be quashed. If you don't have a case, your petition will be dismissed.
My lord, kindly see, it is correct. My lord, kindly see, kindly see the annexure E, my lord.
I will not say now. You just answer to my query.
I also made also, my other criminal petition, petition 1513. Who is this? Who is this infected in annexure E, my lord? Page 20, my lord.
No, Mr. What is your name? Mr. Das. Das, what I am suggesting, you have filed a criminal petition for quashing a criminal proceeding. We can,
The one I got was. Yes, my lord.
why are you so restless? Are you understanding what I am speaking to you?
Oblige, my lord, oblige. It is correct, my lord. I am so.
I am there to hear you. I will hear you if required. But what I am suggesting, you have filed a criminal petition
Oblige, my
for
lord.
quashing of the criminal proceeding. Notices were issued. The other side has already appeared. The
LCR also received.
LCR is also before us.
Yes.
Then why we should go for an interlocutory application? Why not dispose of the matter in its entirety? You choose a date, we will fix it. After vacation, we will dispose it of instead of going for. This is my suggestion.
Oblige.
Agreed? Choose a date. No.
Because I is filed because in the law court is
When the date is,
an order passed on 9 September.
both of you are unable to communicate properly.
Oblige, my lord, oblige.
So therefore, what I am suggesting,
Yes, my lord. लेकिन but my lordship law court from law
Time
court
was-
someone
yes,
is
sir.
issued my lordship. Someone is issued my lordship.
you
Lordship, next,
Where is
next
When is-
date is fixed on 21/8/24, just
Twen-
before that date,
21/8.
21/8/24.
Okay, before 21/8
date.
we will fix.
Yeah.
LCR is there. Heard Mr. A. Das, learned counsel for the petitioner. Also heard Mr.
Petition.
B. Gogoi, learned additional public prosecutor, as well as Mr. A.T. Sarkar, learned counsel for the respondent number 2. As the record, as the LCR has been received and the service is complete, this would be in main criminal petition. Service is complete. Let this matter be listed for final hearing on Tuesday date.
From your convenience.
What day? After vacation.
केतिया लगे? After vacation,
23/7, 23/7,
23?
23/7.
Oblige, my lord. 23.
Yes,
केतिया कोई दिया?
23/7. I have
Oblige.
Oblige.
item number.
May I please the lordship? Lordship, 439 application lordship. I have been behind the bars for last lordship, 28 days lordship. Offenses is main offenses lordship 354B lordship. Kindly see-
Case diary would be required.
Yes.
Heard Mr.
A.K. Ahmed.
A.K. Ahmed, learned counsel for the petitioner. Also heard Mr. B. Gogoi. Let the case diary be called for. When?
22/7.
22/7 for case diary.
Much.
Item number.
May it your lordship, my lord.
20?
In this case, model 376, he is there, madam. Now, the
376?
not maintainable. madam.
376?
Three,
3.
madam.
Then
By tomorrow.
by
Within 2 days.
within 2 days.
Steps will go
steps
by
within-
registered postman.
Steps within 2 days.
Oh, by police.
As per the, I have already dictated.
May I please, your lordship. Lordship, we have 438 application, lordship. Lordship, may I come to page 8 of my petition, lordship, that is the FIR, lordship. FIR, at page 8.
Yes.
May I read, lordship?
What is the
The allegation here, lordship, is that one Pulennath was arrested in a case, lordship, that is Sipajar PS case number 9424. And from police custody, lordship, he escaped with his wife and his nephew. And the allegation against this petitioner is that he escaped in the vehicle of this petitioner, lordship. That is the allegation, lordship.
what is your name? Mokazir?
Mukasir.
Zakir.
Yes, lordship. Actually, what happened, lordship? I have a vehicle, lordship, and this petition, this Pulennath and his family is known to me, lordship. They told me that they will go to the police station to because he was
You
arrested.
escaped from police custody.
Yes, he escaped from police custody, but very next day he surrendered, lordship. I have annexed that order. So he said that under apprehension of torture in police custody, he escaped from police custody.
Pulennath escaped. And what is your role?
My role, they have alleged that
You
they-
helped him in escaping.
Yes.
Yes, that is the in my vehicle, but that is
Then
not
did you help or it is without your knowledge?
without my knowledge, lordship. Suddenly they came out from the police station. My vehicle was there because they took my vehicle to the police station for meeting that petitioner in the police station, his wife. And suddenly they came out and police was chasing them. Then they said, "You move," and under fear, lordship, I have to leave. So and the next day, lordship, they surrendered, lordship. There I have annexed that page 14, lordship. Lordship may see that it is they may surrender before the court, lordship.
No.
They said that
Heard Mr.
M. Ahmed.
M. Ahmed, learned counsel for the petitioner, also heard. Yes, Ms. Das. Let him appear.
Yes.
We are disposing on top. Heard Ms. N. Das, learned additional public prosecutor, also heard Ms. N. Das, learned additional public prosecutor. This application under section 438 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Mozakir Haq, alias Mozakir Ali, who is apprehending his arrest in connection with Sipajhar PS case number 95/2024 under section 120B/353/323/224 of the Indian Penal Code. Whether police were assaulted?
No, lordship. That allegation is there that they pushed him and they escaped from that custody.
The gist of accusation in this case is that on 19/6/2024, one Dharani Dekar had lodged an FIR before the officer in charge of Sipajhar police station, inter alia, alleging that on 18/6/2024, the co-accused Pulen Nath, who was arrested in the case of in connection with Sipajhar PS case number 94/24, was kept in police custody, and in the afternoon at about 2 p.m. in the evening at about 7 p.m. on the pretext of drinking water, the co-accused Kulennath and his nephew pushed the first informant and escaped from custody in a Bolero vehicle. The said Bolero vehicle belongs to the driver of the said Bolero vehicle was the present petitioner. Learned counsel for the petitioner submits that the petitioner is an innocent person and he is not involved in the offense alleged in the FIR. His vehicle was hired by Kulennath on the date of alleged incident. It is also submitted that later on, both the accused, namely Kulennath and Pranitanath, have surrendered before the police on the next day. And the petitioner is also ready to cooperate in the investigation. And stop. I have considered the submissions made by learned counsel for the petitioner as well as learned additional public prosecutor. On perusal of the materials available on record, it appears that the co-accused Kulennath has alleged in a application which was filed before the Court of Learned Subdivisional Judicial Magistrate Mangaldoi that he escaped only as he was apprehending severe torture in police custody. And it also appears that the only involvement of the present petitioner is that his vehicle was hired by the nephew of the
nephew and the wife.
Of the co-accused Kulennath, who have now already surrendered. Considering above noted facts, if it appears, this court is of considered opinion that if the above named petitioner cooperates with the investigating officer, his custodial detention may not be necessary for fair completion of CRPC case number 95/2024. So in view of the above named petitioner is directed to appear before the investigating officer of CRPC case number 95/2024 within a period of 10 days from the date of this order and cooperate in the investigation. If he does so within the stipulated period of time, he may be allowed to go on bail of ₹30,000 with one surety of like amount, subject to the satisfaction of the arresting authority with following conditions. Condition number 1 included. This anticipatory bail application is accordingly disposed of.
I am obliged.
May I please, Your Lordship?
Okay.
Yes.
Your Lordship, this is a 438 bail application and the FIR is at page number 16. Your Lordship, one unique fact about this particular case is that there is no aggrieved party. I am not an FIR named accused, and moreover, this is one pressure group, political kind of pressure group who has given a case against me, which is an entire management committee of a gift coupon game, Your Lordship. This is not against any specific person, but against entire committee or an entire group which organized the game, Your Lordship. The FIR is at page number 16, Your Lordship.
What is the allegation?
Your Lordship, the allegation in simple terms is mismanagement of conducting the entire gift coupon draw game And the allegations are so vague to the nature is that they are claiming why have not any local resident of that particular place won any draw of lot. That is a draw of lot game competition, Your Honor. There is the organizing committee cannot ascertain who will win and who will not win, Your Lordship. Moreover, Your Lordship, annexure number 4, 5 are the permission given by the SP and the DC of Sonitpur district, Your Lordship. Also, Your Lordship,
for conducting that gift.
Indeed, Your Lordship, for conducting that game, Your Lordship. And subsequently, Your Lordship, that game was conducted live and streamed across all news channels, Your Lordship. Moreover, Your Lordship, the committee has already filed all the necessary documents before the district administration. And if Your Lordship may kindly refer to page number 51 of the petition, annexure number 10, all the allegations which are mentioned in the FIR are answered via this annexure, Your Lordship, annexure number 51, which is on 11th of June already submitted before the district administration, Your Lordship. And therefore, there is no aggrieved party. One pressure group is trying to extort money from this particular people who were organizing this game for the aid and construction of a temple.
Yes, Ms. Das.
Lordship, let them appear, Lordship.
We are willing to appear, Your Lordship, and submit everything before the SP.
Heard.
TL Oscar, Your Lordship.
Mr. T.A. Laskar, learned counsel for the petitioner. You want it to be disposed of or case diary?
Case diary, Lordship.
Also heard Miss N. Das, learned additional public prosecutor. This application under section 438 of the Code of Criminal Procedure, 1973, has been filed by the petitioners, namely Dushmanta Sharma and Bhogeshwar Das, who are apprehending their arrest in connection with Telamara PS case number 40/2024 under section 420/406/468/34 of the Indian Penal Code. The gist of accusation in this case is that on 17/6/2024,
Pardon, Your Lordship, on 10/6/2024.
you have mentioned it 17.
Your Lordship, the FIR is submitted on 17th. The game occurred on 10th of 6.
No, FIR.
FIR
On 17/6,
76.
2024, one Deep Soika and a few other persons and 13 other informants had lodged an FIR before the officer in charge of Telamara police station, inter alia, alleging that the organizing committee of the gift coupon game which was held on 10th June 2024 for the aid of the construction of Surabhi Ashram Harihar Mandir had indulged in mismanagement. And where is the allegation?
Your Lordship, we have answered each allegation with an annexure. At large, the allegations are
Certain anomalies were committed while conducting the said gift coupon game. It is also alleged that in conducting the said gift coupon game, no tax was paid. Where are the names of the accused?
Your Lordship, there is the name is given as the entire committee, Your Lordship. There is no specific person named as an accused person, Your Lordship.
By the said committee. Where is that allegation that committee has been?
Your Lordship, may referred to.
Yes.
Your Lordship,
What
page
is the
number
last line?
18.
By the, and various other anomalies were conducted by the Lottery Game Management Committee. Learned counsel for the petitioner has submitted that the petitioners are the members of the organizing committee of the said gift coupon game, which was held in aid of Shri Surabhi Ashram Harihar Mandir, and for conducting the said lottery game, gift coupon game, all necessary permissions were obtained from the district administration. And no anomalies were performed. No anomalies were conducted in conduct of the said gift coupon game. Learned counsel for the petitioners have also submitted that the petitioners. Now, why are you apprehending your arrest?
Your Lordship, the police has registered a case and the police has given us a call that a lot of people are creating pressure that they should start investigation, whereas the SP is aware of the fact, Your Lordship.
The petitioners, learned counsel for the petitioner has also submitted that as the petitioners are the members of this organizing committee of the gift coupon game, after registration of the FIR, the police is searching for them, and therefore they are apprehending their arrest. It is also submitted that the petitioners are ready to cooperate in the investigation. On the other hand, learned additional public prosecutor has submitted that the perusal of case diary would be necessary for consideration of the instant anticipatory bail application, hence call for the case diary fixing
On 23rd.
July for case diary. However, in the meanwhile, considering the submissions made by learned counsel for the petitioner, as discussed here in above, both the petitioners are hereby directed to appear before the investigating officer of Thelamara PS case number 40/2024 and cooperate in the investigation. If they do so within the stipulated period of time, in the event of their arrest, both the above named petitioners shall be allowed to go on bail of rupees 30,000 each, with one interim bail of rupees 30,000 each, with one surety of like amount, subject to the satisfaction of the arresting authority with following conditions, number 1 and 2. Let this case be listed again on 23rd.
Much obliged, Your Lordship. Much obliged.
I have 64 months application.
Yes.
Yes, that is the Lordship. My 438 application and FIR is a page 10, madam. FIR is a page 10, madam. What happened in this case, madam? The informant was the owner of a cheaper truck, madam. And during the lock time, he could not pay installment. Because of that, the finance company impounded his vehicle. Later on, madam, he came to the proprietor of MM Motors seeking some help, madam. And it was told that the informant should first clear his unpaid dues. And because of that, he handed over some money to the proprietor of MM Motors, Mr. Mujibur Rahman Bhoglia. And it is alleged in the FIR, Mujibur Rahman did not deposit the money, neither issued any checks in the name of Tata Motors. And when informant met the Mujibur Rahman, he gave him 2 checks, of HDFC Bank, which when he deposited, the state got dishonored because of insufficiency of funds. And because of that reason, the FIR was lost, seeking for recovery of the money. Yes, my case is that I am not the proprietor. I'm not the proprietor of MM Motors, I work there, I'm an employee. My name is Sharafuddin Bolgia. And because Lordship at page 10, Lordship will find Mujibur Rahman Borbuya within the Shorof.
You are not Mujibur.
No, my lord, I am not Mujibur Rahman Borbuya.
No money is paid to you.
My lord?
No money was paid to you.
No, no money was paid to me, my lord. My proprietor returned the money through checks, which got dishonored. So admittedly, my lord, there is no criminal liability on my part, my lord. And apart from that, my lord, this is informant has other effective remedy, my lord, on the city. That is a negotiable issue. He could have, my lord, approached the court, my lord, seeking relief under 138, my lord. So my humble prayer, my lord, Lordship, may kindly protect me and my lord, allow me to cooperate with investigation.
Heard Mr. M.A. Chaudhary, learned counsel for the petitioner. Also heard Ms. N. Das, learned additional public prosecutor. This application under section 438 of Code of Criminal Procedure, 1973, has been filed by the petitioner Sorofuddin Barbhuya, who is apprehending his arrest in connection with Algapur case number 49/2024. This 2024 under section 120B/420/468/405/506 of the Indian Penal Code. The gist of accusation in this case is that on 3/5/2024, one Halim Uddin Laskar had lodged an FIR before officer in charge of Alagapur police station, inter alia, alleging that the informant was paid two checks.
My lord, 2 checks was paid to the informant.
The informant was paid 2 checks by the proprietor of MA Motors as the same money as for payment of rupees 7,40,852. However, it is also stated in the FIR that the said money was due to the informant. However, when the check was presented for encashment in the State Bank of India, same was dishonored due to insufficiency of fund. It is alleged in the FIR that the accused Mujibur Rahman Barbhuya, within brackets Saraf, had cheated the informant. Learned counsel for the petitioner has submitted that the petitioner's name is Sorofuddin Barbhuya, and you have not issued check.
No, madam,
And he is not the accused who has been named in the FIR. It is also submitted by learned counsel for the petitioner that the petitioner is only an employee of MA Motors, and the said checks in question were issued by the proprietor of the MA Motors to the informant. Learned counsel for the petitioner has also submitted that the facts narrated in the FIR shows that the offense under that allegation is relating to an offense under section
138 of negotiation.
138 other steps are there. Offense under section 138 of the Negotiable Instrument Act might have been committed. However, the petitioner is no way in is involved in no manner in the offence alleged in the affair. He also submits that the petitioner is ready to cooperate in trial. On the other hand, learned additional public prosecutor submits that perusal of the case diary would be necessary. Hence, call for the case diary, fixing
25th July.
25th July for case diary. In the meanwhile, considering the nature of accusation leveled in the FIR and submissions made by learned counsel for the petitioner as discussed herein above, the above named petitioner is hereby directed to appear before the investigating officer of Algapur PS case number 49/2024 within a period of 10 days from the date of this order and cooperate in the investigation. If he does so within the stipulated period of time, in the event of his arrest in connection with Algapur PS case number 49/2024, the above named petitioner shall be allowed to bond bail of rupees 30,000, interim bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the arresting authority with following conditions. Condition number 1 and 2. Attempt. Yes.
Yes, my diary received here. Case POXO is there, my lord. My friend is appearing for the informant. My lord, he is behind the bar, my lord, 89 days.
89.
No, my lord. Today is complete 90 days, my lord.
Complete today.
Today is. My lord, one item is fixed tomorrow, my lord. Item number 17, my lord. Today's item number 17, my lord, can be fixed along with my lord. Item 11, my lord. Same case diary, my lord.
Item 39, Lordship. Jail inside jail for last 30 days, Lordship. And diary is also here, Lordship.
Here, another item, my lord.
Item
35. He has completed 92 days, my lord. 35, 35.
Mine is 39. Mine is 39, Lordship.
My lord, item 17, my lord, with tomorrow's 11, my lord. 70.
35. Who is for
Yes, 92 days. Petitioner. Yes, 92 days. My lord, already distributed over. Yes,
70.
Your 30,000 with one surety of like amount.
Special just POXO Golbara.
Mine is 39, Lordship. One only theft, Lordship.
No, but it has to be hard.
Lordship. Yes.
Can it be item 70 with tomorrow's 11?
Here, Lordship.
No, now we have a reference.
Lordship, then tomorrow, Lordship. Tomorrow.
Okay.
Tomorrow, Lordship.
Item 70 tomorrow, my lord, with item number 11. Same case diary.
Court master.
Lordship, mine is item 39 tomorrow, Lordship.
No, I would suggest you take dates from court master.
Yes,
but vacation courts are also there.
Yes.
If it is very urgent, you may fix it before vacation court.
Tomorrow, mine is 39 tomorrow, Lordship.
Vacation code may be allowed to be. Those who have CD, my lord. I have CD, my lord.
Okay.
That can be done, Lordship.
I had a small prayer, my lord. One order sheet your lordship wanted, my lord, in item number 65. Can I give it, my lord? Today's case, my lord. 65, my lord. Already lordship had dictated the order itself, my lord. Only the last order, certified copy of the order sheet, my lord. Item 65, the supplementary. Nobody did. Okay.
Lordship,
65.
I'm
Well,
still
should we
waiting
mention
for
before
39, Lordship. Very urgent, Lordship. Tomorrow. Tomorrow.
Mine is
If
also
they
tomorrow
apply.
with 11, my lord. Same case. Item 70 today, my lord, with item number 11 tomorrow, my lord.
41, my lord. Same,
Right,
my lord.
এক minute, I think. Hold over there. এটা বৰ বেয়া দেখি ন photo.
No.
Already in the list, my lord. Item 11 tomorrow and today 70, my lord. Same case diary.
You make prayer before court master.
Yes, ma'am. Yes,
he will accommodate
My lord.
considering our
My lord, my lord,
number of cases on the board.
my lord. Right, you can.